Join me in standing for the Pledge of Allegiance. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. And with that, I'm going to open the public hearing on Senate Bill 29 and recognize Senator Carson to introduce her bill.
Good morning, Mr. Chairman, and good morning, honorable members of the House Criminal Justice and Safety Committee. For the record, my name is Sharon Carson, and I have the pleasure of representing Senate District 14, comprising of the towns of Londonderry, Hudson, and Auburn. And I have for your consideration this morning Senate Bill 29, which seeks to repeal the statute relative to police matrons. Ladies and gentlemen, it is 2023. And to use the term matron in discussing our female police officers is antiquated and quite frankly insulting. And it's time that we do away with this term and honor the women in blue who are out there every day serving us. And that is all that this bill does, is it removes the term matron. We do have some women police officers here today who will speak with you. And this bill really came from the New Hampshire Associations of the Chiefs of Police. And again, this statute has been in existence since 1915. And quite frankly, we've come a long way, baby. And it's time that this needs to go. So, Chief, I believe Emily Cobb from the New London Police Department is here to testify and can answer any questions that you have. So at this point, Mr. Chairman, I will end my testimony, and I hope that your committee can look favorably on passing this bill. Thank you very much for your time this morning.
Thank you. And I think probably only three of us get the Virginia Slims reference.
I know.
Seeing no questions for Senator. Thank you.
Thank you.
The chair recognizes Chief Emily Cobb.
Good morning. Thank you, Chairman Roy and committee members. My name is Emily Cobb, and I currently serve as the police chief for the town of New London. I'm a lifelong resident of New Hampshire. I began my law enforcement career over 18 years ago as a police officer in my hometown of Claremont. Then I moved on to the New London Police Department in 2016, and I've been serving as chief since March of 2020. One day not too long ago, I was reading through RSA 105, Police Officers and Watchmen, when I came upon 105.5, Police Matrons. And the RSA reads, quote, "Women may be appointed as police matrons, and thereupon shall have, within the limits of the city or town, all the powers conferred by law upon constables, except in relation to the service of civil process." I had read this RSA years ago, long before I became a police chief, and I remember thinking to myself at the time that that seems outdated. But despite my thought of it being outdated, I didn't feel at the time that I was in a position to enact any change. Fast forward to my more recent reading of RSA 105.5, this time as a police chief. I had a conversation later that night with my husband, who is also a police chief, about police matrons, and I mentioned to him I thought it should be repealed, and he encouragingly said to me, "You know, you can do something about that now." And he was right. So I soon reached out to Beth Sargent, and I'm honored to be here today testifying before you in support of this bill on behalf of myself and the New Hampshire Association of Chiefs of Police. Mr. Chair and members of this committee, this RSA was enacted over 100 years ago in 1915, and a lot has happened since then. Over those 100 plus years, many, many women have proudly taken the oath, honorably worn the badge, and bravely protected the people of our great state. In recognition of all the women who came before me and my fellow female law enforcement colleagues of today, I offer my gratitude to them, their families, and their sacrifices. As female law enforcement professionals, we bear many titles in addition to that which is inscribed on our badge: wife, mother, daughter, sister, friend, and more. One title we should not continue to permit in the codified laws of the state of New Hampshire, however, is matron. The Merriam-Webster definition of matron as it pertains to a police station is a woman who supervises women or children. That was indeed the role of women in New Hampshire law enforcement in our history, a role in which they fulfilled a critical and valuable need in the protection of people in our society, a role which they should be applauded for. However, times have changed, and New Hampshire law enforcement has evolved. I offer to you, Mr. Chair, and members of the committee, that women in New Hampshire law enforcement today are certainly more than what this outdated statute provides for. And so on behalf of myself, my fellow female law enforcement colleagues, and the New Hampshire Association of Chiefs of Police, we are asking that you repeal 1055 as it is an antiquated statute that can be removed from New Hampshire law. We ask that you vote ought to pass on Senate Bill 29. I remain grateful for your consideration and appreciative of your time today. Thank you.
Thank you, Chief. Just a question. I agree with everything you said, but I have a question regarding that role. Are there currently anyone in the state that you're aware of appointed as a matron?
None that we are aware of. We did ask through the New Hampshire Association of Chiefs of Police to all the chiefs in the state if there were any currently serving police matrons, and we did not receive any responses that there were.
And the historical role would be if a female was arrested, the matron would search and et cetera. Is that correct?
Essentially, yes. Yes.
So for departments in the state that do not have a female police employee, how would they handle that situation?
Much in the same way that I would search a male prisoner.
Yeah.
We are trained at the New Hampshire Police Academy on how to appropriately search and process someone of a different gender. And so I suspect that in a department that doesn't have female law enforcement officers, they would revert to their training and how they were taught to search someone. Again, much the same way I search male prisoners.
So
arrestees.
the name notwithstanding, there's no role for this position.
Not as far as the New Hampshire Chiefs are concerned, no.
Good. Okay. Thank you very much.
You're welcome.
Further questions? Seeing none, thank you for your
Thank
testimony, Chief. That's it. Is there anyone else wishing to testify on this bill who has not testified on this bill? Seeing none, I will hereby close the public hearing on HB 29, and the committee will stand in recess. No, it's noted for tomorrow. We'll be in recess till 9:30.
Terry?
This time I open a public hearing on Senate Bill 38, and I recognize Daley Frenette.
Wait, you need somebody to introduce the bill.
He is.
Good morning, Chairman Roy and members of the committee. My name is Daley Frenette, and I am the Senate Majority Caucus Director. I'm here today to introduce Senate Bill 38 FN on behalf of Senator Gannon. Senator Gannon is currently in the hospital, and he regrets not being able to be here in person. If signed into law, Senate Bill 38 FN would improve RSA 594:14 by amending the procedure for issuing a summons instead of an arrest. This bill would authorize law enforcement to issue a summons in lieu of arrest if the officer has probable cause to believe the person has committed a misdemeanor or violation. For example, under current law, a person who has failed to renew a dog license has committed a violation. Even though it is only a violation under RSA 594:14 in its current form, arrest is the only option for law enforcement. While current law allows a judge to convert an arrest warrant to a summons, it unnecessarily requires law enforcement to file with the court, resulting in an unnecessary use of law enforcement and judicial resources. The judicial branch discussed this bill with both the chiefs of police and ACLU, and both indicated their support for the bill. The Senate Judiciary Committee amended the bill so the statute would not apply if a peace officer has probable cause to believe that a person has committed abuse, violated temporary or permanent protective order, or violated stalking provisions. The bill was unanimously voted ought to pass the amendment on the consent calendar by the Senate. Thank you for allowing me to speak today. I will defer any questions to Richard Head from the Department of Justice because he will be able to answer your questions more effectively.
Thank you, and please extend the committee's well wishes to Senator Gannon.
I absolutely will. Thank you.
Chair recognizes Attorney Head from the court.
Good morning, Mr. Chairman, members of the committee. My name is Richard Head. I'm the Government Affairs Coordinator for the Judicial Branch. As Daley said, we have spoken with ACLU, police chiefs, and the DV Coalition regarding this bill. All have signed off on the language. And this is a bill that we've requested, and it's from our end, our perspective, a resource issue. So we get requests for arrest warrants on events that simply should not be an arrest warrant worthy event. So for example, as Daley said, there are certain requirements that trigger an obligation under current law to seek an arrest warrant. If the event is committed in front of an officer, they can arrest. If under statutory provisions, if there's a violation of a domestic violence order, or otherwise a protective order within a certain number of days, an arrest can occur without a warrant. Or if there's an immediate risk of concealing or destroying evidence, an officer can arrest without a warrant. But otherwise, an arrest warrant is required, requires going to the court. And this is for both misdemeanors and violations. So, if you have an unpaid dog license fee and that gets referred to law enforcement under current law would have to get an arrest warrant. And what typically happens is the judge is going to either convert that to a summons, or what also sometimes can happen is at the discretion of the officer that arrest warrant is obtained, but the summons is issued in lieu of the arrest. Simply based upon the nature of the event that is given rise to the need for an arrest warrant. This is a discretionary option available to law enforcement. It does not require a summons being issued in lieu of. So it's really, those instances where it really does not give rise to the obligation and the record of having received an arrest warrant and having to go through the arrest process. So it is, from the judicial branch's perspective, sort of an unnecessary filing that comes before the court, an unnecessary use of the judicial resources when these can really be decisions that can be made at the law enforcement level. So with that, I'd be happy to answer any questions that the committee may have. Thank you.
Thank you. So what this would do is the criminal complaint would issue upon the writing of the summons versus the way it was now is the criminal complaint would issue because the officer had to arrest the person.
That's correct.
So this would
it
just,
bypasses that arrest warrant stage where they have to petition the court for the arrest warrant, and allows the criminal complaint to be issued with the summons or as a summons.
any further, Representative Salig?
Thank you, Mr. Chair, and thank you for taking my question. Can you just clarify if we pass this, what are the circumstances where, like, or give maybe a couple of examples of where a warrant would still be required? Because I'm just trying to discern that from the language and getting caught in my own head.
A warrant could be issued in any of these cases. This does not limit the officer's ability to seek and obtain an arrest warrant. This bill is limited in terms of providing the discretionary option only in misdemeanors and violations. But it is in no way a mandate on law enforcement to issue it as a summons. But in and of itself, it only applies to misdemeanors and violations.
Representative Rhodes?
No, it's right.
Oh, sorry, Representative Gathright.
Thank you, Mr. Chair, and thank you for taking my question. I guess I have a concern about that it's up to the law enforcement to make the decision, and if there's no guidelines behind that. So,
And so thank you for pointing that out. So there are guidelines. It's the same guidelines that one would have for the arrest warrant. So the language is still has probable cause to believe that a person has committed. And that ultimately is the standard by which the summons would be issued or an arrest warrant would be issued. This simply does it similar to what would happen in a traffic stop. You get a summons instead of an arrest warrant. Ultimately, if there is a defense to that, that can be raised before a judge to say there was no probable cause for this summons to be issued. So it doesn't take the court out of it. It simply eliminates the arrest warrant that would be issued to that individual, where a summons is a more appropriate.
follow up. Okay, I think I understand what you're saying. However, I guess for me, if you have if it's up to their discretion, how can I say this? If it's up to their discretion and a person decides, that the law enforcement officer decides not to use this method that's in here, and therefore has to get a warrant, what's the difference? At what point is that decision okay? Or are you going to have documentation? For me, we do have issues in law enforcement in New Hampshire, and particularly when it comes to people of color. And so for me, is there going to be any documentation, just to make sure that everybody's getting the same type of treatment with this law in place?
So thank you for the question. I think a couple things actually. We are in our system working on being able to extract data about individual sex, ethnicity, personal data that we currently do not extract out of our system. Our diversity and inclusion group is trying to work on our data so that we can extract more, drill down a little bit more in terms of information that we have in our system. We currently, either for arrest or summons, and to be clear, under the current system, arrest warrants can be converted into a summons. It's just done by a judge instead of the law enforcement officer. So then if we are able to ultimately input data that can get issued into reports, which we're working on, the answer to your question will be yes. And that is something I think we're very close to being able to start implementing. It won't be old data because we don't have that in our current system, but as we move forward and are collecting more information and more data into our system, we'll be able to generate more detailed reports that we currently do not.
Thank you.
Representative Janman.
Thank you, Mr. Chairman. As it stands now, if a person, they have reasonable suspicion,
Probable cause.
thank you, probable cause that a misdemeanor has occurred, they have to go before a justice of the peace or a justice.
If it did not occur in front of them,
Yes, right, 594-10 notwithstanding. So they would go to them and they would have to swear out a complaint. That judicial officer would make an arrest warrant.
they would have to request the arrest warrant. That's correct.
So if we pass this bill, that would take that third person out of the, I think that's what she was getting at. It takes that third person out of the equation.
So it doesn't take that. I didn't mean to interrupt.
No,
your
go
question.
right ahead.
It doesn't. So thank you for that question. It doesn't take the judge out of the equation. It changes when the judge becomes involved in the equation. So the judge is always going to be reviewing that complaint when it comes before them. And the standard is still the same. So there's simply the imposition of an arrest warrant may not happen in that first instance, but at the end of the day, the nature and quality of the decision making of the arresting officer, of the charging officer, still gets judicial review.
If I could, just for the committee, there seems to be a lot of confusion. Currently, a police officer can only apply for an arrest warrant. There's no choice. Now, this bill proposes to let the police officer say, this is a dog license violation or an overdue library book. Let me just write a summons to the person. It goes to the court instead of the officer going to the court in the beginning and getting an arrest warrant. That's all that this does. It gives an option.
The follow-up.
Representative Jammer.
And just to follow up on that, much like with a speeding ticket, speeding summons, that happens to happen in front of the officer, but that is, still able to be and is reviewed and by a judge.
I think as a follow-up, the question I would have for you is, you're releasing the person on a summons in lieu of arrest, and I'm reading the form that we're proposing here that the court be using, and it says,
The form is actually the current form. That's not new in this bill.
okay, I'm familiar with it, unfortunately, but it says pending appearance as described herein, you shall remain of good behavior. So in lieu of bailing them from an arrest, you're going to be basically putting the same condition on them under the summons. How are we keeping track that they're released on a summons if they're interacted with by a police officer at a further date?
In much the same way as currently, once in terms of the behavior of the individual, if they are again before a law enforcement officer and the law enforcement officer is aware they've been issued a summons and they have this obligation, it would follow essentially the same course, whether it's good or bad. It wouldn't change sort of the obligation on the individual. On our end, we probably need to make sure our forms, our summons forms and our charging forms have all that language in it.
Representative Newman.
Thank you, Mr. Chair. Thank you for taking my question. I'm a little bit confused about the words that have been omitted here, just based on the description that we've had of what the current status is. And it originally said, the law originally said, in any case which it is lawful for a peace officer to arrest without a warrant. So it seems like you could arrest without a warrant and you could do a summons maybe. I just don't understand. Is the important thing that part of the bill, or is the important thing the part of the bill down here where it puts in all these references to other laws? Is that the important part, or equally important, or maybe you could straighten that out for me?
So thank you for the question, and I appreciate it. So under current law, and in the way, as you noted, it reads, in any case in which it is lawful for a peace officer to arrest without a warrant. And then it goes on, for a misdemeanor or violation. Under current law, this gets triggered. So the ability to only issue a summons instead of an arrest warrant has to meet the criteria for when it is otherwise lawful for an officer to do that. And that standard is laid out in a different statute. Under RSA 544.10, it lays out the criteria for when an officer can issue a summons instead of a warrant for an arrest. And really, under what the section that's being amended for is the summons form. So there are essentially three primary reasons why under current law an officer can issue a summons instead of an arrest warrant. One is if the crime occurs or the violation occurs in front of the officer, then the officer can issue a summons instead of an arrest warrant. Second is if it's a domestic violence or a protective order violation. If it occurs within a certain period of time, a summons can be issued instead of an arrest warrant. And then the third one is actually I forgot what the third. Oh, if the officer has information, probable cause to believe that the evidence will be destroyed if the time is necessary to go off and seek an arrest warrant. So take my example of the dog license. The dog license is a violation. Failure to pay your dog license fee is a violation. It does not occur in front of the officer. So under current law, the standard that's crossed out where it says it is lawful for a police officer to arrest without a warrant, it did not happen in front of the officer, so it is not lawful under current law for the officer to issue a summons in lieu of an arrest warrant. What this bill does is it strikes that language and says that an officer can issue a summons in lieu of an arrest warrant if they have probable cause to believe a misdemeanor or a violation has occurred. So it really takes out that in a very sort of low level event, the obligation under current law of an officer to get an arrest warrant for that individual who has not paid their dog license fee.
Could I have a follow-up? So it more or less has the same standards and everything, and it just makes it simpler and more efficient, maybe. Would that be a good estimate of what it is?
It is the same standard. Probable cause is still required for the officer to issue the summons. It reduces so for example, I have on occasion not paid my dog license fee on time. If I were to get an arrest warrant for that, I think most people would be pretty shocked that they're getting arrested for failure to pay a dog license fee. They would expect something along the lines of a summons. And I think that's really what we're trying to address in this, rather than an officer coming to the judge then having to say, that's not what we need to do. We need to issue a summons and authorize the summons. It just reduces that judicial resource need, but does not eliminate, at the end of the day, the judge's review of the actual complaint.
Thank you very much for that explanation.
Representative Stone.
Thank you, Mr. Chair, and thank you for taking my question. So just to be clear, there's still be a requirement that a probable cause affidavit is filed with the court, even though a summons is issued?
They would not issue an affidavit. It would be described in the summons what the event was, and then ultimately when the judge is reviewing that summons in the context of the substance of it, they would be determining whether or not there was probable cause for that summons to be issued. So it's not an affidavit at the time of the summons. The summons lays out the facts, and actually the complaint lays out the facts, sorry. And that ultimately gets reviewed by the judge, but a separate sort of affidavit like you get with a request for an arrest warrant it's just a different document, but the review is still the same at the end of the day.
Thank you.
Representative Wheeler.
Thank you, Mr. Chairman. Thank you, Attorney Head. I'm just a little bit confused as about the bill itself as well, and I'm wondering if there's any concrete examples that you have of this happening where an officer has to arrest someone for a violation. You know, the dog catcher example, has that happened before? And do you know?
It has. Another one would be a kid who takes an ATV out and trespasses on someone's property, and just gets picked up for that. It's along those lines that we're talking about.
Representative Muse.
Thank you for taking my question. I'd appreciate it if you could maybe walk me through how this law doesn't have potential to create a level of disparity between, let's say, officers in one community may kind of get together and decide, okay, we're only going to treat this particular type of crime or violation, that we're just going to issue a summons for that. Whereas in another community for exactly the same crime, officers could say, no, I think we'll do, we'll have to issue an arrest warrant. I think the guidelines in the bill are pretty clear for things like stalking violations, but there seems to be an incredible amount of discretion. And I guess in your opinion, are we opening the door to treating people in different communities in different ways for the same crime?
So thank you for the question. I think as a practical matter, some of this may not change anything, because sometimes, and this has been relayed to Judge King, that sometimes the arrest warrant is obtained because that's the requirement, but a summons is ultimately, the person is contacted and they say, come down and get your summons. It is simply, in terms of why we brought it forward, is it eliminates sort of the judicial resource step of getting an arrest warrant where it simply is clearly not needed. I think, in terms of law enforcement, you've heard plenty of testimony from law enforcement that, the issue of repeat offenders is a concern for them. We're not talking about that type of situation. We're talking about low-level offenses where an officer simply has they recognize that the person receiving an arrest warrant in that circumstance is an excessive event for the nature of the crime or violation that has occurred. And I think as a practical matter, it may not change at the end of the day what that person is receiving, where law enforcement currently may be getting an arrest warrant, and it's either getting converted by a judge to a summons, or they're simply issuing a summons at the time instead of an arrest. So as a practical matter, I'm not sure it would change anything. I think, if there is concern over time that there is a disparity occurring, we obviously can be revisited. But in terms of our experience now, it is simply, those events where it would be truly shocking for the individual to receive an arrest warrant when they would expect to see something more along the lines of a traffic violation.
Attorney Head, if you could indulge me for a second. Just so everyone understands, currently the officer doesn't have, there's a lot of question about officer discretion. If an officer is referred a case from the town, says this person hasn't paid their dog license in 3 years, the officer has no choice but to apply for an arrest warrant at this point. Is that correct?
At that point, the officer has probable cause to believe a violation has occurred. Same thing that would occur under
Right.
this bill.
So, but he has no options. It's the only way to get that person to court is an arrest warrant application. Is that correct?
Yeah, that is correct. So absolutely, under current law enforcement has to come to court, seek an arrest warrant. As a practical matter, once they've obtained that warrant, they've complied, and they may issue a summons at that point. But the arrest warrant is still required, and that arrest warrant now is on that individual's record in terms of the court record.
So the officer goes to the court for the dog license issue, applies for an arrest warrant because that's what he has to do, And the court at that point can look at it and probably will look at it and say, no, you can have a summons because we're not arresting people for dog licenses today. What this does is lets the officer, instead of having to go to court to get an arrest warrant, because that's all he can do, is he can write out a summons to give the person, which is what the judge would have done anyway.
Exactly.
Thank you.
And at the end of the day, that summons and the complaint that goes with that summons is going to be reviewed by a judge. Just now, it doesn't have to be done twice.
Thank you. Thank you. No further questions then.
Thank you.
Anyone else? Is there anyone else who wishes to testify on this bill who has not testified on this bill? Seeing none, I'm going to close the public hearing on Senate Bill 38. Committee will be in recess for 5 minutes.
All these RSAs in this all has to do with intimate partners, stalking, and marital properties. I just looked them up. Yeah, I know.
So,
So
I was on this radio interview once, and it was with some friends, and the one girl said how she has a dog, and she just totally forgot to renew his license, and then when it had been decided
this point, I'm going to open the public hearing on Senate Bill 182, and the chair recognizes Senator Regina Birdsell to introduce her bill.
Thank you, Mr. Chair. Thank you, committee, for hearing Senate Bill 182. For the record, my name is Regina Birdsell. I'm State Senator for District 19, which encompasses the towns of Derry, Hampstead, and Windham. And I am the prime sponsor of Senate Bill 182, which is the relative to the definition of way in driving or operating under the influence of drugs or liquor. This bill was a request from the Derry police chief based on a decision from a Supreme Court decision, Diana Rudder versus Director, New Hampshire Division of Motor Vehicles, which left a hole in the DUI laws with regard to the definition of way. Simply, what this bill does is it extends the definition of way to 7 additional RSAs. 265:71, which is stopping, standing, or parking. 265:79, it includes it in the rules of the road. 265:A-2, driving under the influence of drugs or liquor. 265:A3, aggravated driving while intoxicated. 265:A-4, operator to submit to testing to determine alcohol concentration. 265:A-25, commercial motor vehicle drivers. And 265:A-31, administrative review and hearing. And I know that I have members of I believe the Derry Police Force here to speak on it as well.
Thank you. Any questions for the senator? Seeing none, thank you.
Thank you.
The chair calls Chief Scott Jordan. Chester.
Good morning. My name is Scott Jordan, and I work for the Derry Police Department as a prosecutor. I've been doing this for about 35 years. I was a full-time police officer before going to law school, and I've prosecuted basically that entire time as a police prosecutor and as a assistant county attorney, deputy county attorney, and now I work for the town of Derry as their supervising prosecutor. What happened was last year, the New Hampshire Supreme Court, in this case, it's Diana Rudder versus, I believe it's Department of Motor Vehicles. The Supreme Court, in its ruling, sorry, let me just get this part together. In its ruling, basically said that because of the language of 259-125, which is the definition of way in the state of New Hampshire. Now, there's 2 parts to way. The first part is very generic, and it applies to almost all motor vehicle offenses. The second part, part 2, is an expanded definition of way. And it encompassed 4 RSAs, and that's the only 4 that were listed in it. It encompassed DWI, aggravated DWI. There was a parking system for emergency parking by the Department of Transportation, by the commissioner, to put in certain signage. That one is considered in there. And then there's 265-79, which is reckless operation. So the ones that we're dealing with primarily is the 2 DWIs, the aggravated DWI and regular DWI. Now, in the case involving Ms. Rudder, the Supreme Court ruled that since the ALS statute 265-A:4 and the other enumerated ones that we've listed, I believe 21 and 31, are not included directly in the definition of way, like the DWI statute, then they don't apply. So as such, in this case, a woman who was arrested for drunk driving in a church parking lot did not face the ALS, the administrative license suspension rules. So in other words, the obligation to consent to blood doesn't apply. The penalties for refusing or testing over do not apply. So basically what happens is, and I remember when we started making these arrests in 1991, 92, under the ALS and DWI have been married at the hip for over 30 years. And now they've been separated. Now, in this order, and I'd have you all read the last page of this order. It was an invitation by Justice Marconi, Hans Marconi, excuse me, who said this is how we can correct it, simply by adding it. And the legislature took this as a judicial oversight, and they're giving the opportunity to have it corrected. And that's what we're asking you to do. We're not asking for anything new. We're asking just to be returned back to the last 30 years of how we've been doing business, and the fact that DWIs and ALS run hand in hand. And it's basically making this separate now depending on where you're arrested, what road you're arrested on. Is it a private road? Is it a private parking lot? If so, ALS won't apply. And it's disparaging, or not disparaging, but it gives a uneven, execute very even-handed, and go across the spectrum when it came to DWI and ALS.
Thank you. In this case, the defendant was subject to the OUI laws, just not the administration section of it. Is that correct?
Correct. She appealed the imposition of the ALS suspension for testing over, and the Supreme Court ruled that it should not have been applied to her.
So going forward, if this were to pass, well, actually presently, someone could be arrested for OUI, found guilty based on the observations of the officer, and they refuse the breath test and the blood tests. They can't lose their license for that, but they can lose it for the OUI. Is that correct? Currently.
Correct. But if you remember, the ALS is an intermediate remedy.
Right.
It's an immediate remedy in regards to the DWI. If a person is arrested and they refuse to take a test, in 30 days, their driver's license will be suspended by the Department of Motor Vehicles. Now, they have a right to have a hearing and have due process regards to that. But a DWI arrest, it can take a year. The way we're doing in COVID, I've got DWIs right now pending that are 3 years old plus because of the backlog in the court. So you're talking about a drunken driver who's arrested by the police, charged. And if this case had been in place, they could still have their driver's license with no penalties whatsoever for 3 years. And that's what the legislature in 1991-92 was trying to avoid and put in place, a way of getting these people off the road and protecting the public.
Representative Prue.
So that 3-year-old case, the person gets his license suspended in 30 days. Is it still suspended for 3 years because you haven't had a hearing?
No, sir. The ALS has its own separate and distinct penalties. So if a person refuses to take a test, and this is the first time, they lose their driver's license for a period of 6 months. Now, if they're convicted of the DWI sentence would go on top of that. That's a penalty for refusing. It's going to be consecutive. However, if they took a test and they're convicted of the DWI, then they're still going to lose, if they tested over a .08, they're going to lose their license for 6 months under the ALS. However, that 6-month penalty will run concurrent. So at the same time as any penalty that the court gives them for a license suspension. And if it's, say that DWI is 2 years out now, and you did the 6 months up front, then that 6 months will be credited towards that, any suspension that the court gives them.
Okay, thank you.
You're welcome.
Representative Bolden.
Thanks for taking my question. I believe the Supreme Court decision said that they don't know and can't speak to the legislature's intent in structuring the law in this way. Do you know what the legislative intent was? I haven't had the opportunity to look back that far in the RSAs yet. And is it possible that it was maybe a Fourth Amendment consideration, considering that it's private property?
I don't believe so, no, because I don't believe so. The current DWI legislation, which current one provides for that expanded definition. That makes no sense where they were plugging in the ALS to be a stopgap method to get people off the road. It doesn't make any sense. They wouldn't have included that. And if you read Heinz Marconi's dissent, you'll see that that's exactly what she's stating in her dissent, that it's implied. And the legislature says, we're not going to take it as implied. Or I'm sorry, not the legislature, but the overall court. We're not going to take it as implied. If it's not written, and it's very, in fact, or the court is only looking at what is written in the law. There's only 4 statutes. So they're saying we can't interpret this. But I can tell you in practice that the ALS for the last 30 years has been married to the DWI, and there's never been a question about it. The police, prosecutors, as well as defense attorneys and the judiciary have always agreed, up until this last case, that ALS and DWI go hand in hand no matter where it is.
Thanks for letting me ask another question. I remember a little bit of what I read in the majority opinion on this case, and I remember that they said that there are situations in which you might have administrative license suspension without a DUI, and situations in which you might have a DUI without ALS. Can you speak to what kinds of situations those would be? Because I think that was the court's reasoning in supporting overturning the conviction. They were saying they're not married at the hip.
Well, I don't believe the court said that. Where there are situations, and they don't talk about them in the order, and the only one that really comes to mind is the person who tests positive for drugs, because we don't have a level of drugs. So if the blood comes back that the person's under the influence of drugs, then no ALS goes into play, because they didn't test over a 0.08, which is only for the alcohol. We don't have levels on drugs. And as such, there is no implied consent penalty that's applied. However, still the ALS rights are read to them, like the fact that refusal is going to be used against you in a court of law. All those rights are still in play, and they're still given to the person. But that's the only one I know of.
Would one of the cases be a junior operator, perhaps, where they're not allowed to have any alcohol in their system, where it would cause an administrative suspension?
For a person under the age of 21, it's a 0.02. If they test above a 0.02, not if they just smell alcohol in their breath, if they test above a 0.02, then their driver's license will be suspended for that 6-month period for a first offense.
Representative, go ahead.
I'm just trying to parse out kind of the reasoning of why way would be different. And if I could just give you a scenario and you tell me if this would apply. So I'm home, it's the summer, it's beautiful weather, we're all barbecuing in my backyard, right? My son wants to play basketball. He's got a couple of friends who came over. Now, in order for him to play basketball, I have to back up the car 15 feet so he can get to the basketball hoop and things like that. Well, I've had a couple of drinks because I'm barbecuing at my house. I'm in my own driveway. If I back up that, 10 to 15 feet or whatever and am confronted, would that be a situation where this doesn't apply now and would apply if we implemented this law?
This wouldn't apply now, and it wouldn't apply if you amend the statute. Just like DWI wouldn't apply for you in your driveway either.
Okay.
The extended definition of way, which DWI falls under, does not cover private driveways. It's private parking lots that are designed for the public. Other people come in other words, it's not just designed for the family. This is my private parking lot in my house. That's a driveway. And DWI, there's nothing in the way statute that would ever cover that property.
Okay. Thank you.
You're welcome.
Representative Bolden, one more.
Last one, unless you keep being interesting. Apartment building complex parking lot.
Apartment building complexes are covered under the statute. That is not a driveway. That is open to the public. Not only are the tenants allowed there, but anyone visiting the tenants. You have children who go out and play in that area. So yes, those are covered currently under the DWI law, and they wouldn't be covered technically under the ALS, given Rudder. So we would look to put that back under with the DWI law.
Representative Newman.
Thank you, Mr. Chair. Thank you for taking my question. So I'm just a little confused about what the way the law is. It says an act, it's relative to the definition of way in driving under the influence of drugs and liquor. So, but when I look at the current law as written, it has way in there, and I don't see anything in the bill that has anything to do with the definition of way. I just see that the change that is made in the law is just to add the 3 RSAs that you mentioned. So I'm just curious, is it the definition of way, or is it just that you want, that this bill intends to incorporate the ALS laws with, I'm not sure what, with ways?
The change that we're looking for is within the words and phrases and the definition of way. They expand the definition of way, and it says for the purposes of these statutes, this is going to be the definition of way. So all we're asking for is, there are currently 1, 2, 3, 4 statutes that are in there. The current definition of way, or the current definition of way under section 2, is the definition for these statutes. So for DWI, aggravated DWI, and for reckless operation, and for that parking statute, the expanded definition of way is applicable to those statutes. And it's always been applicable to ALS until this court order. All we're asking is that you put that back inside the definition of way under 2 and be applicable to the administrative license suspension. And that's what those 3 RSAs involve, the ones that are added on to the end.
Right, I understand the ALS, but I just don't understand. There's a there's no other definitions at all, and there's no definitions in here. Are there definitions, excuse me for the follow-up? Is the definition in the 3 RSAs that you, where exactly is the definition of way?
The definition of way is within the statute we're looking to amend. If you read past the 3 RSAs, it says any public highway, street, avenue, road, alley, parking lot, or parkway, any private way laid out under authority of statute, ways provided and maintained by public institutions to which state funds are appropriated for public use, any privately owned and maintained way open for public use, any private parking lots, including parking lots and other out-of-door areas of commercial establishments which are generally maintained for the benefit of the public. So that is the definition, the expanded definition of way under section 2 of the definition of way.
Thank you, I'll reread this.
Thank you for your testimony.
You're welcome. You all have a good day. Do you want this?
Yeah, just. The chair calls Chief Abeki.
Could I, with your permission, Mr. Chair, I'd just like to have our prosecutor stay up here for a few more minutes. So, Mr. Chair, members of the committee, my name's Joe Hobecki. I'm the immediate past president of the New Hampshire Chiefs of Police, and I'm also the Chief of Police in Hollis. I speak today in support of this legislation, and I urge you, the committee, to pass this. To give you some historical perspective, in August of 2022, received an email from a concerned chief, so happens to be your boss, about this statute and some inconsistencies with the definition of a way. I think this is an important and necessary change. I won't reiterate, and I'll keep my remarks brief, anything what my colleague here has mentioned, but I do think it's important to reiterate the fact that within the Supreme Court ruling, the final paragraph of the order says that our legislator has sought to close various loopholes and get tough on DUI by making changes to DUI law. And I think that's important to remember here, and it's appropriate given the fact that last year alone there were 134 traffic fatalities in the state of New Hampshire in between 2009 and 2018, which is the most recent data I could find. provided by the CDC, there were roughly 354 fatalities in New Hampshire contributed to impaired driving. So these changes are needed, and I would urge you to support this legislation. And I thank you.
Thank you, Mr. Chairman. Could you just repeat those statistic numbers you just gave? I didn't have my pen ready fast
Sure.
enough.
No problem, ma'am. 134 traffic fatalities in 2022 in New Hampshire. That was of December 30th, 2022. And then between 2009 and 2018, a 10-year period, as provided by the CDC, there was 354 fatalities in New Hampshire contributed to impaired driving. So this is important. This is very important.
Representative Bolden.
Thanks for taking my question. I wanted to clarify the quote that you cited from the Supreme Court ruling. Was that from the minority opinion, the dissenting opinion?
It was, yes. Yep.
Thank you for your testimony.
Thank you, Mr. Chair.
Is there anyone else wishing to testify on this bill? Was not. Seeing no one, I'll hereby close the public hearing on SB 182. Committee will be in recess until 10:30.
Thank you, Chairman Roy and honorable committee members. For the record, my name is Senator Deborah Altshuler. I represent Senate District 24, which includes the towns of Exeter, Greenland, Hampton, Northampton, Hampton Falls, Rye, and Stratham. And I'm here to introduce Senate Bill 244 relative to false public alarms. In the beginning of this current school year, CNN published an article about the fallout from active shooter hoaxes, beginning with a school in Arkansas and multiple schools in Florida. Students, teachers, and parents all traumatized by this experience. You have that article coming around to you. Then it was our turn in New Hampshire. Less than apprehended, we terrorize our communities and exhaust our resources. That's the purpose of this bill.
In which instance can you point to where this has happened in New Hampshire from an adult? Has an adult committed a false report on a high school or school here in New Hampshire?
I thank you for your question, Representative Wheeler. What I can point to is that there have been 12 false reports of active shooters that have cleared out schools, that have traumatized communities, that have traumatized children who are in those schools. And when those perpetrators are apprehended for these false reports, they will suffer nothing more than a misdemeanor violation. And it is the opinion of the New Hampshire State Senate that that is inappropriate and that this kind of terrorizing deserves to be acknowledged for the seriousness that it is. Thank you.
Representative here at Gathright.
Thank you, Mr. Chair, and thank you for taking my question. I actually have the same concern that Representative Wheeler has.
Mhm.
And I looked at some of the notes from the Senate, and the question was, bad eyesight. And the answer was yes, but it's not likely to happen. Would you have a problem in some type of amendment that would kind of not allow that 15, 16, 17-year-old to be charged with a felony?
So currently, that is under the judicial discretion of our county attorneys and our attorney general. Your mic isn't on.
Sorry about that. The current statute, as I read it, already has at least one type of incident that already is a Class B felony if it's called in, and that's if somebody calls in a false report of a biohazard. So there is precedent for doing something like this in our statute, correct?
Indeed, there is precedent for this. So a biohazard, and the Senate has also added in bomb threats. So we have a heavier penalty on calling in a biohazard than we do in calling in an active shooter hoax. So, you know, this seeks to acknowledge the seriousness of that.
Follow up, please.
Follow up.
And part of the reason for separating incidents like this from incidents, for example, just pulling a fire alarm at a high school, and I think we've all been through that. But one of the reasons why you might treat this differently is because the level of police and resource response, the level of fear and the type of response, especially after Uvalde, it can generate in parents. Calling in a threat of this nature would appear to just really kind of put this type of an offense at really a totally different level than some of the other things we're usually talking about. Is that how you see it?
That's indeed how I see it.
we have required our schools, by the change in our culture, to prepare for an active shooter. And the preparation includes drills. And every time we do that, we now know that our students are, are traumatized because they know what happened in Nashville. They know what happened in Parkland. They know. They're not unaware. They're not unaware at all. Little ones are not unaware. Older students are not unaware. And when a hoax comes in and sends a community into panic, and parents rush to the schools, and the state police rush to provide mutual aid, and like in the towns that I mentioned before, 10 towns all on one day responding to their schools, 10 communities sent into tailspins. That's a serious, serious thing to do. And it deserves a serious response from our judicial system, in my opinion, and in the Senate's opinion.
Representative Selig.
Thank you, and thank you for taking my question. My school system was also subject to one of these hoaxes, terrorist hoaxes, prior to the school day beginning because of our later start time, so they were able to clear it before students arrived, thankfully. But one of the many impacts you talked about is the fiscal cost of bringing in all these resources. I'm wondering if you have information. Let me be clear, I support your motion, but I'm curious for people who might not be able to see past the certain elements, but to the fiscal cost of what it is, and if you have a sense of how much that is in terms of bringing in all of these resources to a school.
Well, that would be an interesting collection of bills. But if in the article that you have, which is referenced in my testimony as B, and it is from Seacoast Online, and it references the training that our school community engaged in prior to school beginning, so that they were prepared. Anytime a local municipality has to send everybody out and call in for mutual aid, that's a significant cost.
Yes.
Representative Newell.
Thank you, Mr. Chair, and thank you for taking my question. I appreciate this very much. As a mother of a high schooler who I believe sometimes don't take it as seriously as it should be, and it absolutely should be. My question is, when there's something like that Keen experienced, where it was a TikTok trend, and I'm not saying, I'm not condoning that whatsoever, but my question is, if someone shared something on social media that was something like that, would they still be accountable in the same way?
So this bill specifically refers to hoaxes that are called into schools that then subsequently warrant response. And all practice, policy, and precedent right now shows that response is as if it were real. So I can't speak to whether your municipality would do an all-out response from a social media post, or they might do an investigation into that social media post. But when a school receives a call saying there's an active shooter in the building, they have to go into their predetermined response. I couldn't speak to, this bill doesn't address if somebody saw something on any kind of social media platform. We're talking about actual calls that come into the schools.
Okay, can I follow up really quickly? Just really quickly. So,
Yeah.
so essentially at that point, what it seems to me like it's dependent on the level of response. So in Keene, for example, they did find it uncredible. They still went through the school day. My son stayed home and I was fine with that because he was scared. But there was an investigation, but not an all hands on deck because they did not find it to be credible because it was TikTok. So the distinguishing factor of whether it would be prosecuted in this way or not is not whether it's a phone call, but it's the level of response. Am I clear on that, or maybe not so much?
I'm gonna have to take a moment and possibly refer back to you or refer back to the committee in writing. I need to formulate a more articulate response, but this bill does not address potential threats that have not occurred from social media or potential threats from rumors. This is actual threats, actual reports of an active shooter.
Okay, thank you.
So, yeah.
Representative Newman.
Thank you, Mr. Chair, and thank you for taking my question. You referenced that a Class B felony is 3.5 to 7 years. If something like this were to happen, isn't it the outcome may be the judge will determine whether it's first offense, the ability of the person thought they were fully aware of that, so the potential punishment could be much, much less. Could even be a misdemeanor or lower. Is that correct?
Thank you for the question, Representative Newman. As this bill is written, it does leave prosecutorial and adjudication within its current leeway. It offers the opportunity for a judge, should they want to, or should it be appropriate, to bring the potential incarceration of a maximum of 7 years, because that is what we have determined in New Hampshire to be an appropriate response to a Class B felony. This proposal is to bring this very traumatizing and terrorizing event into the umbrella of Class B felonies, but it is not, we don't have mandatory sentencing for Class B felonies. There's judicial discretion. So indeed, you are correct.
Follow up? And I might not have been clear. In this state, I believe that for there to be a mandatory minimum, that mandatory minimum must be written into the law, which it affects, that makes it, there are mandatory minimums in this state, I believe. If you want to say anything about that.
There's a range. There's a range because we have put a range into our penalty phases. So Class B felonies, this would be a Class B felony within that range.
Thank you.
Thank you.
Representative Muse.
This bill addresses one type of a crime that's become more common called swatting, and when it comes to the level of penalty, my understanding is that other types of swatting incidents have resulted sometimes in people losing their lives or being severely injured. Is that where you could see in the law that we're talking about now, the bill that we're talking about now, is that a situation where you might see a judge using some of that discretion when it comes to maybe going to the farther end of the spectrum, maybe to 7 years or something like that?
Well, I thank you for the question, but I can't hypothesize what a judge may or may not do with that. But your assessment of the intensity of response of these kind of call-ins of active shooters is correct. It is.
When we had it and we thought it was real, our team went down to do that. Thankfully, it wasn't. But the parents racing down Main Street in Concord, that was real. The woman who came and dropped to her knees outside the fence, that was real. We told her. We were standing there as police officers and told her in that moment that it was a fake call. And I was so relieved to tell her, but that what she experienced was real. This is real trauma being under some people, and people need to be held accountable for it. And everyone knows what is happening in our country. So it's not a hoax. It's not a joke. This is serious. Thank you.
Thank you, Ms. Hawkins.
Thank you.
Mr. Holbecki? Chief Holbecki, I apologize.
Morning again. Madam Chair, members of the committee, my name is Joe Hobecki, the Chief of Police in Hollis and the immediate past president of the New Hampshire Association of Chiefs of Police. I wasn't planning on providing testimony, but I'm happy to do so. The association supports this bill. I asked the question of you all, why are we not doing this? Why would you not support this bill? Turn your television on, open the newspaper, look on the internet. This is becoming more frequent, and it's extremely alarming as a parent to an 11-year-old and as a public service, public safety professional. Some of the things I heard was the immense taxing of resources to respond to these incidents. That is true. It's very true. As a chief, my job is to mitigate risk. It's one of the most important things I do. When you have a large-scale response, I work for a small town, so we rely heavily on mutual aid. When you have a large-scale response, it elevates risk. It elevates risk to everyone. That's one of my overtime. That's time and a half of an officer's hourly wage, and it can become quite costly. Additionally, it creates a heightened level of fear. Are we just to allow this to continue without holding folks accountable? I don't think that's a good option. There needs to be accountability for people who do this, particularly as a way to capitalize on the horrific, gross acts of violence that we see in our schools and in other places of gathering, whether they be places of worship, shopping malls, supermarkets, etc. Be happy to take any questions or try and answer any questions you have.
Thank you, Chief. Chief, are you aware of any arrests made for this crime in this state in the last year?
For what you folks have referred to as swatting type calls, I'm not, Mr. Chair. I can certainly look into that and report back to the committee.
Yeah, I'm interested in knowing, do we have cases where we wished we could have charged a felony but couldn't because the law?
Sure. Yeah, I know they're oftentimes very complex to investigate because folks will use, spoofing apps and things like that. This is such a problem, I'll put it in this context, that the FBI actually has a specific training for public safety agencies, not just police, but also fire, EMS, because oftentimes those folks are taxed to respond to these types of calls. They had to actually organize a training for municipalities so they could be more uniform and standardized in their approach to these types of calls. So it's getting out of hand.
That raises another question, if I may. Are you aware if there's a federal crime for this? Because it is using telephonic, so it would fall under the federal law if they so choose.
I'm sure there probably are federal statutes that do apply to this. I will say, I find it kind of odd that we have in statute 644.3, we have language relative to chemical spills. We have felony level offenses for folks that tamper with fire alarms. But we're arguing over the merits of making a felony level offense for folks that call in an active shooter. Just makes no sense to me.
I would say that we're not arguing. I think that we're just trying to make sure we do
Yeah,
our
I'm sorry.
due
I'm
diligence. That's all.
passionate about this issue. So
I understand. Representative Janvern.
Thank you, thank you, Mr. Chairman, and thank you for taking my question.
Thank you, sir.
So I'm looking to, when Fish and Game gets a call that somebody's lost in the woods and they have to respond, and they respond with many people to go and do a search party, and that person didn't have the Hike Safe card or didn't have a hunting or fishing license, they're usually charged to reimburse the department for that service.
Sure.
With this type of crime, do you think that it would be appropriate, in addition to the felony, to also charge that person for the responding agency's expenses?
It's a valid question. I'm not sure I can give you a good answer. I know the courts would probably have issue with it. I mean, we've, in various instances where people have committed violations or crimes, I can think of when I was a member of a SWAT team where we've tried to bill folks for overtime for the folks that were responding to the call, and the courts can go either way. Judges are typically very cautious to mandate restitution like that for certain cases. So I guess my answer to you is I don't know how to answer. It's a difficult question to answer. In theory, I think it's a good idea, but I don't know how the courts would perceive that and see that.
Representative Murray?
Thank you, Mr. Chair, and thank you, Chief, for taking my question.
I was looking forward to it.
Is it not true that sometimes these calls can be made by potential shooters to almost see like what the response is like, and so they can make plans for their, crime in the future? So if we passed a bill like this, it potentially could stop a shooting before it even happened, as the person would be arrested and charged with a felony before they even had the chance to carry something like that out.
Valid argument, valid point, and that's true. Oftentimes, folks will test response, and that's not a new phenomenon. They've done that with things such as bank alarm response and such for many, many years. So it's a valid point, and I would agree with your question/statement.
Representative Selig.
Thank you, and thank you for taking my question. I've been doing some work recently related to PTSD and first responders,
Yes.
and in addition to all of the PTSD that this would cause teachers and students and parents, I'm curious if you could speak to how responding to these calls might trigger PTSD in first responders, and for people who might be more focused purely on fiscal aspects rather than on practical and safety ones, what the financial impact of having that occur might be.
So in my opinion, these could be, what they refer to as triggering events for folks that maybe have existing PTS conditions. Certainly it elevates, an officer's hypervigilance when you're responding to these calls, whether or not they're legitimate or not. I don't know if any of you have had the opportunity to watch the video from Nashville. If you haven't, please do. Listen to the officer's breath. That will indicate to you the stress placed on the human body when you respond to these critical incidents, whether they're legitimate or not. So I am very concerned about the increases as it relates to PTS and having it be a triggering event. As you said, there are costs, not just in terms of resources per se, but the burden placed on people. There's liability issues, workers' compensation. It's hard to quantify the dollar amount fiscally that with the impact as it relates to these types of calls and these types of instances.
I'm curious if the Chiefs Association has seen officers who are leaving the force because of this type of threat.
I'm sure there's some. I mean, these are tough times for law enforcement, and I think we're losing a lot of folks. I saw a recent statistic where I think statewide we're down roughly 300 officers or more from what was a more robust, I guess, population of officers in the state, 10 years ago. There's a number of police officers leaving the profession, whether it be by way of retirement or just simply resigning. And I think heightened stress and the threat to safety is one of many factors leading to that. Thank you.
Thank you, Chief, for your testimony.
Thank you, Mr. Chair.
At this point, no one else willing to testify, wants to testify, going once, going twice, closed. At this point, I am going to open the public hearing on Senate Bill 245, and the chair recognizes Daley Burnett again.
Good morning, Chairman Roy and members of the committee. Hello again. My name is Daley Frenette, and I am the Senate Majority Caucus Director. I'm here today to introduce Senate Bill 245 on behalf of Senator Ricciardi. Senator Ricciardi was asked to sponsor this legislation by the New Hampshire Lodging and Restaurant Association. The bill is really a housekeeping bill to update the law to better reflect the reality of the industry with modern technology. RSA 353:3 requires a lodging establishment to keep a record of the guests that have booked rooms and to make that record available to public safety personnel if necessary. This statute was enacted in 1927, well before the advent of computers. Now that this information can be kept electronically, it's about time that we update the law. There really is no need for a hotel to keep a book or card system to have the guests sign in. SB 245 removes the antiquated reference to book or card system and simply requires the hotel to keep a record of the guests. Senator Ricciardi has drafted amendment language, which was sent to the committee a few days ago. Senator Ricciardi hopes that a member of this committee will be willing to have this language drafted in their name so that the committee can consider it as a committee amendment. The amendment language addresses an issue that arose in the Senate Judiciary Committee. At the last minute, the committee amended the bill to keep the language in the law about the guest providing their legal name or the name by which the guest is commonly known. When it did so, it reinserted the word sign. With remote check-in and check-out, there is sometimes no need for the guest to sign in. This amendment language removes the requirement to sign in and simply requires the hotel to keep a record of the guest's legal name or by which the guest is commonly known. Thank you for allowing me the opportunity to speak today. I will defer any questions to Henry Vayu and the New Hampshire Restaurant and Lodging Association. Thank you very much.
Thank you. Roy Schweiker. Wait a minute, there's a person from the Hotel Association. At this point, the chair recognizes Henry Vayu.
Thank you, Mr. Chairman and members of the committee. For the record, my name is Henry Vayu, and I'm here on behalf of the New Hampshire Lodging and Restaurant Association. And I have to say, I think this is the first time that I've testified before this committee with the Lodging and Restaurant Association. I live up in the Commerce Committee or in the Labor Committee, so I don't think I've ever been here for the Lodging and Restaurant Association, but it's a pleasure to be here. As was just explained, this is really a housekeeping bill. It's not intended to change any policy. The statute right now, RSA 353:3, requires the hotel basically to keep a record of the guests. And if public safety suspect there's a suspect there, that they could come and check the record of the guests and confirm whether or not the individual is there. We don't intend to change any of that. What we simply want to do is update the language in the statute. As it was mentioned, it was enacted in 1927, that speaks to the hotel keeping a card system and a book for the guest to sign in. I mean, that's so antiquated. The industry now, as you know, it's all online. You can check in remotely. So we've crafted the language so that it basically says, look, you just got to keep a record of the guest and keep it open to inspection by public safety. When the Senate was getting it out of the committee, they had the hearing was done. We left the room. They finished a few more hearings, and at the end of their hearings, they said, we can get this bill out really quickly. One of the senators wanted to reinsert the language that is in the current statute that says you keep their legal name or the name by which they are commonly known by. They wanted to put that back into the bill, and they did, but they also put the words that are in the statute to say they sign their legal name, which we want to get away from that. That was the whole intent of the bill. So the amendment that was presented, that hopefully you have before you, takes the reference to signing out, and it basically just leaves it as we wanted to, which is just keep the record of the guest and keep it open to inspection. That's it. It's a simple bill.
Thank you. Just one question. How, when it's all computerized, if an officer comes in and says, I'd like to see the list for today, how would the hotel go about showing them that? Like in the book, they could just flip to today's page.
Right. Can I have Mike Summers? He's the CEO of the organization.
Sorry. So my name is Mike Summers. I'm the president and CEO of the New Hampshire Lodging and Restaurant Association. So the way the industry works these days is everything is digitized. So if a law enforcement officer were to come to the hotel and want to see the records, they would just take them into the office or behind the front desk, and they would give them the computer screen and just show them, okay, who are we looking for? So it would all be ultimately be digitized.
So if they, for example, wanted to see everyone who checked in today, they'd be able to just call that up on the screen?
Oh, absolutely. Yes.
Okay.
Yep.
That's all I was
a lot of these hotels, they can do it remotely from, their corporate headquarters. They can see how many guests checked in, who the guests are, et cetera, et cetera. So all that information is available. It would just be a case of them going behind the desk and give them a monitor to look at, and they could go through the records.
Thank you.
Yep.
Representative Murphy.
Thank you, Mr. Chair, and thank you for taking my question. I just have a question about the listing of the guest names. I'm assuming that's the guest who booked the room, but not anybody who might be staying with them. Like if I booked it in my own name, my husband could be a guest. So you don't really have a full description of who's in every room, just the person that booked it.
Correct. And that's been the historical standard. Yes.
Okay, thank you.
Representative Saitek.
If this is to be used by law enforcement, I think I might suggest words like this, and I'd ask what you might think. Such a record, the legal name of each guest and the name by which the guest is commonly known if different. Or, no, and. That the name that's commonly used if it is different than the legal name. Because, I could come in and say I'm Cher, and I don't tell you what I...
Well, and frankly, I think that that's a technicality that the committee could certainly address. I think the intent for us is to update what the statute, because technically most hotels today are in violation of the current statute, because currently they're supposed to keep a booking card system. Nobody does. It's just exorbitantly expensive and time consuming. And they're also, many of them are not requiring anybody to sign anything when they check in. They're just checking an ID. So ultimately the language that you feel more comfortable with, I think we're fine with, just so long as we're maintaining those two changes, because that just updates to what the industry practice is today, if that makes sense.
But I think to your point, that may be more grammatically correct as you describe it. Or either their legal name or the name by which they're common.
Thank you. And thank you both for your testimony. Sir, if you could fill out a pink card just so we have you for the records.
Yep.
At this point, the chair recognizes Roy Schweiker.
Thank you, Mr. Chairman and members of the committee. I'm Roy Schweiger from Concord, and I agree with the fact that this thing about the card system is obsolete and needs to be changed. But I feel that this whole thing is obsolete and needs more changes instead of catering to the wishes of one senator. I mean, I understand, the old days, the sheriff would wander into the thing and see who the strangers in town are and look at the list of guests. And I don't think that's appropriate anymore. My recollection is there was a certain bill that the same committee acted on, which had to do with unjust criminal prosecution, HB 89, where some operator of a camp refused, even with a warrant, to give the names of the guests there. And he was convicted, and this committee just essentially vacated that conviction. This was an unjust prosecution. He was entitled to not give out the names of the people that attended his camp. And I think the same thing could be true with hotel records. Why does the police have a ability to just wander in and ask who's staying at the hotel? I would say it might be more correct to do what hotels do now. If you call up and say, is John Smith staying at the hotel? They will admit if he is, and they'll connect you to his room, but they won't tell you where his room is. It's up to John Smith to decide if he wants to admit this person that wants to talk to him. So I think we need to delete that whole sentence regarding the showing the thing to the police, because I don't think it's appropriate. If they need to know the list of everybody in the hotel, let them go get a warrant. And even then, apparently, this committee feels that even with a warrant, it may not be desirable for the hotel to give out the list of people. So I would say that whole business about showing the register to the police officers needs to be removed. And the second thing that essentially is taken care of, maybe, with this amendment about signing the register, that once again, the current bill or the current statute says that every member who's staying there needs to sign it. Once again, I would say this is something that is not enforced, either, not just the signing it, but like someone said, if one person reserves the room, you may not know who else is staying there. And this bill, if it is implemented, even minor children would have to, show up and have their name listed, even if they don't have to physically sign something. I think that, once again, maybe you want the hotel owner to know the name of every person, including kids and whatever who's staying there. But I'm not sure that that's true. It's something they probably aren't doing today. So this is, in effect, if you pass it as written, you're, should we say, saying that the current statute is correct and they should be keeping those detailed records. And since presumably they'll now be expected to follow it now that you remove the cards, then they'll be expected to follow it in terms of the names of everyone who's there. And, I'm not sure that's appropriate. Maybe it is, but certainly I think this business of any police officer walking in and saying, I want to know everyone who's staying here, that's, kind of not in keeping with what we do elsewhere. I mean, once again, you read about the Airbnbs, they have random people staying there and causing all sorts of trouble. Well, they're not affected by this. They can still have, 10 people show up and live there because they're not a place with 2 or more rooms. So they're exempt from this, whereas the hotels that don't have that problem will have to follow it. So I think that's inappropriate. Thank you.
Thank you, and those are good points. The committee will take those under advisement. And, Representative Newman.
Thank you, Mr. Chair. I just have one question. You referenced a bill that was in front of this committee. Could you do that? Just give me that number again.
HB 89 relative to posthumous exonerations and annulments.
Thank you.
Is there any further, anyone else wishing to testify on this bill who has not done so? There being none, I hereby close the public hearing. Committee be in recess for 2 minutes. this point, I'm open a public hearing on Senate Bill 245. No, excuse me. Senate Bill 81. And I recognize Jenny Horrigan.
Good morning, Chairman Roy, members of the committee. For the record, my name is Jenny Horgan. I am the Senate Minority Policy Director, and I'm here introducing Senate Bill 81 on behalf of Senator Prentice. She unfortunately has another bill scheduled at the same time across the hall. So Senate Bill 81 sets a level for alcohol ignition interlock devices at 0.020 and was filed at the request of the Department of Safety and GELCAR. New Hampshire's ignition interlock program requires that any person whose license has been revoked or suspended for an aggravated DWI or convicted of a second or subsequent DWI to install ignition interlock device in any vehicle registered or used by that person for 12 to 24 months. The device prevents the vehicle from starting unless the person provides a breath sample with a concentration of alcohol that is below that preset level. Again, this legislation was filed at the request of GELCAR, who worked with rules to address the installation of the devices during the summer of 2022. So thank you for your time and consideration. As soon as the senator is finished testifying across the hall, she's going to race right over here, answer any questions that you have, but we will note that Director Marasco from DOS is in the audience and does plan to testify. He would be best suited to answer any technical questions. And that concludes my testimony. Thank you very much.
Thank you for coming. And at this, the chair recognizes Jen Bailey, excuse me. Are you Mr. Marasco? You'll be testifying together? Okay.
Good morning, Mr. Chairman, members of the committee. Thank you for allowing us the opportunity to testify before you this morning. My name is John Marasco. I'm the director of the Division of Motor Vehicles, and I'm here with Jennifer Bailey, who is the administrator who oversees financial responsibility at the DMV. I would like to thank Senator Prentice for sponsoring this bill. As was testified to, GELCAR recommended that this bill be put forth. And basically what it allows for, sir, is it allows for the DMV rule set with a set point of 0.020 to align with what we're trying to add here to the RSA. The set point of 0.020 is a NHTSA, National Highway Traffic Safety Administration set point or preset standard, which means when somebody blows into that device at that 0.020 threshold, the vehicle will not start. It should be noted that the actual violation, which is in the statute currently, anything that is greater than a 0.025 will register as a violation. So some of the conversation that occurred before GELCAR was the DMV rule set has a 0.020, but that's less than the 0.025 violation. We're trying to have both documents have the same information. The benefit of migrating to the 0.020 is one, it meets the NHTSA standard. Two, it aligns with the DMV rule set. And three, currently right now for those that would be on the program that are under the age of 21, their threshold for a DWI with being 0.020, if we keep it in the RSA that it just stays at a 0.025 or greater, you could run the risk of a juvenile that's on the program blowing a 0.020 and actually legally driving the car. We don't want that. So adding this to the RSA captures that as well. So it's a really good addition to the RSA, and we fully support it. Administrator Bailey oversees the program, so if you have any specific questions, I know Jen is happy to answer them for you.
Just out of curiosity, why is it 0.020 and not just 0.0? Is that something that's just not technically feasible? Does everyone have a certain amount of alcohol?
That's a great question. My understanding on that, sir, is that it's an industry standard. Most of the devices, although they can be recalibrated, my understanding is that the 0.020 set point not only is what NHTSA recommends, but I think they recommend that because the industry, that's the standard that they're using as well.
Representative Wheeler.
I have some curiosity too. Thank you, Mr. Chairman. Just really how long have these devices been in use? How long have we been using the ignition interlock preset device?
That's a great question. I have the literature on it. Jen's working with it every day, so if you want to take that, Jen.
Good morning, everyone. Thank you for having us. So great question. We have been using interlock devices since about 2012. We have recently expanded that. At any given time right now, we have about 1,300 devices actively being used by residents of New Hampshire. So we had looked to expand the rules to meet certain guidelines, and this is one of those things that we did with emergency rulemaking, and that's when JALCAR recommended that we match our law with that.
I missed it. You said 1,300 devices in use right now?
Yeah.
Thank you.
See no further questions. Thank you very much for your testimony.
Thank you.
Thank you.
Anyone else? Is there anyone else here who wishes to testify on this bill who has not done so? Seeing no one, I hereby close the public hearing, and we will be in recess until 1 p.m.
decomposure, structural damage to the home from the decomposing of the body, biological risks from toxic fumes emitted from the decomposed. Financial loss includes monies spent on hazardous cleaning crews, repayment of Marilyn's pension checks that Craig continued to benefit from over the period of her concealed death, and the loss of our family's real estate value in her home and sentimental artifacts. These are just a few examples from my personal experience of this situation. The financial cost, emotional toll, and time spent by law enforcement on this case could have been avoided if officials were notified of her death as soon as possible and able to handle it properly. If caretakers, family members, or both are unable to report a death, we need to ask why. It is my belief that there is no altruistic reason to conceal a person's death, and that more sinister reasons lay beyond the actions of hiding it. As members of society, it is our duty to the deceased to protect and honor them, just as we would the living. This is something I wish I had the opportunity to do immediately upon the death of my grandmother. She was not just my grandmother, she was also my best friend. It was and it continues to be very hard. I want to thank you for your time and your consideration of your support of this bill. And in closing, I ask that if given the opportunity, humbly, we could name the bill or law after her, Marilyn. Thank you for your time. Does anybody have any questions for me or?
Representative Bolden.
Thanks for taking my question. I'm sorry about everything that happened. Have you been able to obtain any restitution from Craig?
Currently, I have sought legal counsel and I'm working with my lawyer and the trustee of Marilyn's estate to try to handle this situation. Unfortunately, because there's not laws in place that say what he did was a crime, it's been quite a battle. Of course, yeah.
Just quickly, did he also take Social Security checks that were going to her?
So there was a trustee which was managing the money, and so her pension from the New York State school system, and then also Social Security and everything that had been cashed was paid back by that, or taken care of by the trustee. And so there is a little nuance of, did Craig commit a crime financially because he was still benefiting from her monthly income that was coming in? Because he is a beneficiary of her estate in the long run, that is arguably not a big issue, I guess, for, lack of.
Okay, thank you very much.
Yeah.
I think we have everything we need. Thank you very
Of
much. I
course.
appreciate it.
Yeah.
And the chair recognizes Ginny Duvall.
Good afternoon. Thank you. My name is Jenny Duval. I'm the chief medical examiner. And first, let me say that I fully support this bill as amended in the document we're passing around. My only concern is where the amendment is placed in the statute. By placing it under the Office of the Chief Medical Examiner statute, Statute 611, you are restricting the amendment to medical legal deaths. And medical legal deaths are not all deaths in the state. They are deaths that fall under the statute, which is 611B11. There are 26 different scenarios or circumstances surrounding a death that mandate reporting it to the medical examiner. But most deaths do not fall under those 26 scenarios. So if you want to capture all deaths that occur and say all deaths must be reported, then it can't be in my statute and it can't reference medical legal cases. And that's why I think this amendment fits better under the 644:7, which is the abuse of a corpse statute. So that refers to any deceased person whose death occurred under any circumstances. So I just think it fits better in that statute. My other concern is that by placing it under 611, the medical examiner statute, there could be unintended consequences too that would adversely affect our ability to investigate deaths. So that's all.
Thank you, Doctor. Did you raise these concerns to the Senate while this was over there, or is this something that came up late in the game?
I guess I wasn't aware at the time that it was going through the Senate. We did raise some concerns then, and I believe the police testified at that hearing. But I'm not sure it was made clear that what all of my concerns were.
Representative Rhodes, you have a question?
I do. Thank you, Mr. Chairman. I'm not sure if this is already the law or if this is verbiage for a new law, but my question that I have is where it says finds remains which are thought to be human. Is this what they're trying to make be a law? Because my only question is, if I was walking along, I can assure you that I do not have the ability to try to decipher what may be human remains or like animal. So I'm not.
Right.
Like,
So
I would think it should just be reported.
Right. So the proposed amendment, the amendment to the amendment, refers to reporting failure to report the death of a person. So I think we're all thinking of not skeletal remains or a single bone, but we're thinking of a person who died, and I think that the thought behind this bill is referring to a person who dies outside of a healthcare facility. So someone who dies in a home, where someone who shares that home is not reporting the death.
Sure.
So the 611B12 would remain as is minus the additions that were proposed. Is that correct?
That would be my wish. Yes.
Okay, thank you. Representative Sytek.
The proposed amendment says a person is guilty of a misdemeanor. What person is responsible for, how do you, is the person has to be responsible for the care of this person? And if I'm hiking in the White Mountains and I see a remains, am I that person? I think person needs, the amendment has a problem, in my view, with the person having a responsibility over that person, not it.
Yes, I think you could certainly tweak the amendment. I mean, right off the bat, the title of the amendment needs to be corrected because it still refers to a medical legal death, and that's part of the problem. You can certainly tweak this amendment and make it more of the responsible person, although maybe it should apply to anyone who's aware that there is a decedent and they're not reporting it. It probably should apply to everyone.
And that may be accomplished just by saying whoever becomes aware of a death and fails to report it, something like that. Okay, I think we got it. Further questions? Representative Bolden.
Thanks for taking my question. Could you define medico-legal and maybe give us some examples of what's in 611-B:11?
Yes. So as I said,
And then to give the context of like why this isn't where this law should be.
Understood. So 611B11, there are 26, they're lettered A to X. And they describe certain circumstances that mandate reporting to my office. And they are things like deaths where there's some criminal activity involved, any suicide, any accident, any homicide, any traffic-related death, any firearm-related death, any death that's a public health threat or potentially a public health threat, any poisoning death, which would include all of the overdoses that we are seeing. So it's targeted to non-natural deaths, so not deaths from natural disease. It's targeting non-natural deaths or potentially natural deaths, but in a young, healthy person where death is not expected. and where the death may not be natural or may be a public health threat. So that's the idea behind the statute, and it's a good statute. But it would not include your grandmother. You know, it would not include someone who has medical problems, their death is not unexpected, persons who die in their sleep. They wouldn't necessarily have to be reported to my office unless they're not being followed by a physician or another provider who could certify their death.
Thank you. So in your proposed amendment, you're not referencing 611-B:11 at all. And I'm assuming that that's because this paragraph 611-B:12 is just a whole other unrelated thing to their situation. And so we don't need to, if we want to amend this, we don't need to take any of the wording from the bill at all. We can strike out basically dump the bill as is, write something new in a new section that captures the intent. Is that?
Yeah, I think as long as you leave 611 out of it, then we should all be fine.
Representative Saley?
Sorry, thank you very much for taking my question. I'm wondering whether it makes sense in some way to have both parts of this, where it would be a misdemeanor both to report a natural death, as in the case of your grandmother, and I'm very sorry for your loss, but also the medico-legal, I'm sorry, it's an awkward phrase from my mouth, death that, you know, essentially, and I recognize that your proposed amendment references any death, but I'm wondering if we need to be more specific for any reason, just trying to understand the legalities of it.
Is
That
there,
might
al-
be more for the
is
justice
there
system.
already a penalty for failing to comply with 611?
It says mandatory reporting, but there's no penalty referenced. So, yeah, I mean, maybe they should both be amended so that there's a penalty that exists in both. But I still think you want to capture more than just medical legal cases with this particular bill.
Got it. Seeing no further questions, thank you very much. Is there anyone else wishing to testify? Did you want to add? I saw you. Yeah, sure, by all means.
I just want to say that after listening to that, I do think that there is a good point that maybe it falls better under 644-7 and changing the concealing a dead body misdemeanor to felony, and then adding the mandatory reporting rule, which would encompass all deaths and not put anybody in the medical profession at risk in any way. Kind of sounds like the best. So that's just the comment I wanted to make. Okay, thank you.
Is there anyone else wishing to testify? There being none, I hereby close the public hearing. We'll be in recess until 1:30. 1:45. Why did I give so much time? It sounded like it was going to be more. At this point, I'm opening the public hearing on Senate Bill 209, and I recognize Senator Becky Whitley to introduce her bill.
All right. Thank you, Mr. Chair. It's good to see everyone. Good afternoon, members of the committee. For the record, my name is Becky Whitley. I'm honored to represent Senate District 15, which includes the wonderful communities of Bow, Concord, Pennacook, and Hopkinton. Today, I'm proud to introduce Senate Bill 209, a bill ensuring menstrual equity in all of our New Hampshire correctional settings. So I understand that this committee is pretty familiar with this topic. And I'm grateful to bring forward the Senate version. And in my opinion, this bill supports basic human dignity for women in our county jails, our state prisons, and our juvenile correction facilities. This bill acknowledges that for those behind bars, there are some unnecessary hurdles to coping with menstruation and managing periods in a healthy and hygienic way. So I'm really grateful that this bill was the culmination of work with advocates, with the commissioner from the Department of Corrections, and this bill was designed to align actually with an existing policy that the Department of Corrections already has that works to ensure the safety of residents and staff while also ensuring menstrual equity. We also consulted with the county superintendents and got their input on language, and I want to thank everyone who was involved in their partnership for this work. I think this bill is really important, and the subject is really important because menstruation is natural. It's a natural monthly occurrence experienced by half the population for much of their lives, and it should not be treated differently than any other basic bodily function. Menstruation is not something to be ashamed of. However, there is so much stigma and silence around the topic. Menstrual products like tampons and pads are vital for the health, well-being, and full participation of women and girls. Inadequate menstrual support has often been associated with both health and psychosocial issues, particularly among our low-income residents. Lack of access to menstrual products can also take a severe emotional toll, especially if residents are too embarrassed to take part in daily life within the prison or facility. Incarcerated people are in the custody of the state and, of course, rely entirely on prison or jail staff to meet their medical and hygiene needs, including the provision of menstrual products. The ability to manage menstruation should not be a bonus, a reward, an entitlement, or a favor to be begged or bargained for. And that's where this bill comes in. This bill takes away that power dynamic and provides for the provision of the same basic amount of menstrual products for all residents. There's also some flexibility built in depending on an individual's unique needs. Those who menstruate on the panel may know full well that periods can be unpredictable and that not all people menstruate in the same way. Some people have light flows for a few days while others have a heavier flow for a full week. I want to point out that the cost of menstrual products is really negligible when compared to the cost of actually running the facilities. And the government already pays for other necessities like toilet paper. We don't charge for toilet paper, so we shouldn't be charging for menstrual products. This bill, I think, at its core highlights that it's a core human need, even and most especially for people in custody, and should be treated as such. I'm happy to take any questions, and I respectfully ask for the committee's support of this bill. I will note that this bill had unanimous support both in the Senate committee and on the Senate floor. It was amended at the request of a number of folks, including our commissioner, to include our juvenile correction facilities, of which, of course, we have girls. So that's the biggest amendment. And I think there's a few differences that I'm happy to discuss with the House version if that makes a lot of sense. So there is a line in the House version that talks about the provision of underwear. And I certainly would be happy to add that to the Senate version as well. I think that was a great amendment. It's just not something that we thought to include in ours. So I think certainly I would be open to that. I think in ours, like I said, in the Senate version, we do include juvenile detention facilities. I think that's an important thing. We also actually define what an adequate amount of menstrual products is. We say that everyone gets 20 right? And then, of course, there's flexibility from there if I need more. So I think naming that is really important because, again, if you name the number, then you're taking away that bargaining power dynamic. So I think folks thought that naming that number and having that number in there was an important baseline. And that is aligned with what the commissioner already uses in her facilities. And I think she can speak to the importance of naming and why that number was arrived at. So I think those are the major differences. There's some, minor language issues that I'm happy to address. We do define menstrual hygiene products a little differently, and that was very intentional because I think there are certain menstrual products like cups that perhaps may not be appropriate for correctional settings. And I thought that was fine. And so that's why we were very particular in how we named which menstrual products we are talking about here. So I will stop there. I'm happy to take any questions and defer, more technical questions to the able folks behind me.
Thank you, Senator. Yeah, we spent an amazing amount of time on this and delved into it pretty deeply. So we appreciate the Senate doing the same thing. And we're definitely going to compare these two and see which one is better for the people that it protects.
Great.
Any questions from the committee members? I fear everyone here has had their fill of the talk.
Hey, you guys are letting me off easy.
Yeah. Thank you very much for your time, Senator.
Thank you. Thank you. I appreciate it.
Scolabrini. The chair recognizes Tony Scolabrini. Scolabrini? Scolambri?
That's pretty good. Scolambrini.
Scolambrini.
Thank you, Mr. Chair. My name's Anthony Scolambrini. I'm a lawyer in Nashua. Been a lawyer for about 20 years. Some of the cases that I've taken in my career involve people that are incarcerated, involve females that are incarcerated, and on occasion I've sought compensation for people who are injured while incarcerated. Some of the things that some of the changes that were made between the Senate bill and the House bill I think are really good. There is one change that I want to highlight in particular that I think is probably not the best approach. And that change is eliminating the number of menstrual hygiene products per individual. By setting it at a reasonable number as opposed to an actual number, it invites litigation that would be deleterious to the county corrections facilities and to the state prison. I would note, though, that I've never had a complaint about this in any number of years as a lawyer out of the state prison, that it's always been out of county facilities. By putting a minimum number there, it ensures not only that people get some and have them when they need them and maybe could even ration them themselves, but it also eliminates this fuzziness that could invite litigation. I would also note that this kind of litigation would be especially tempting because it would only apply to women. So there would be, not only would there be an issue related to 42 USC 1983, which is the federal statute that allows people to hold state officials accountable for violations of their federal constitutional rights. But because it would only affect women, it also have some equal protection components. And so I would urge the original number to be restored. And that way there is not this essentially red flag for litigation. I'm happy to answer any questions. I hope that I was short and clear.
Seeing none, thank you for your testimony.
Thank you.
The chair recognizes Devin Quinn.
Good afternoon, Chair and members of the committee. My name is Devin Quinn. I'm the Policy Director for the New Hampshire Women's Foundation. We invest in opportunity and equality for the women and girls of New Hampshire through research, advocacy, and grant making. I have passed around two documents. I know that this committee is very familiar with this issue, is very knowledgeable about this issue, and has taken a lot of time and has a lot of empathy for this issue. So I will let some of Ophelia Burnett's testimony speak for itself. If you want to take a look at that, Ophelia could not be here today, but she has been a wonderful advocate on this issue and presents a lot of experiences of individuals who've experienced this issue. So I just wanted to make sure that was in the record. You had that. With your time, I wanted to just focus on the differences between the House bill and the Senate bill, just to kind of get down to what's actually different about them, since I know this is an issue you all support. So in the top here, we have a little spreadsheet, a little chart of what's different about the House and Senate bills. Most of the rest is the same. All of these three things that are different are really great, and I think should probably be adopted into a final bill. The House bill includes underwear, and the Senate bill doesn't. And I know that's something that this committee really did great work in adding, and so I would recommend that you consider adding new underwear to the Senate version of this bill based on that work you did. The only thing I might say is that I know the subcommittee, when I watched that, you had wanted to do new underwear, but then in the language it came out as in new condition. So I don't know if that could be read as if it was sanitized in new condition. That's a question I have, so just wondering if you wanted it to say new or new condition. The Senate bill includes, both bills include jails and the prison, but the Senate bill also includes youth detention facilities, the Sununu Youth Center, or whatever would be applicable in that RSA section. So I would recommend you consider adding youth facilities as well, because we know that people menstruate in youth services as well. The final difference, and which has been brought up a few times, is really defining adequacy as a number, adequacy and sufficiency. So I know that in the House subcommittee, there was a great discussion on timeliness. There was discussion of should it be 1 hour, or should it be a reasonable time, or different questions around timeliness, which were really helpful. I think when we get to the issue of why some folks are getting menstrual hygiene products in prisons and jails and some aren't, it really comes down to that there's either really a system or there's kind of a lack of a system. And so the women's prison and many jails have a good practice, a best practice, where there's a standard amount in practice that are handed out or doled out in an efficient manner at the beginning of a 4-week period, so that it meets with the menstrual cycle. That's probably good for prisons and jails, I imagine, because it's an orderly fashion. It's a functional system. It's also really good for people who are incarcerated who menstruate, because they can count on those pads and tampons. They can count on having them ahead of time. They don't have to wait until they're on their period to ask. And then on the other side is just a few jails that are not in that system, and it's really more of an ad hoc system. And someone has to wait until they're in need to ask, wait for a corrections officer to come around, ask for it, wait to receive it. It might not be in the amount or the type they need, and they might go through that an hour later and need more. And so it's kind of a system or an ad hoc system. And sufficiency or adequacy really, and timeliness are the issues, having enough and having them at the right time. And so the Senate version that actually puts a minimum number, and to be clear, this is a minimum number, not a maximum or a specific only to that number. It's a minimum number. I think that's the only way that a number could actually achieve adequacy without, as Tony had mentioned, having to litigate what adequacy means or what sufficiency means. Because a corrections officer might think 3 tampons is sufficient or adequate. And so if you're debating sufficiency and adequacy, you're putting the very people we're trying to fix this issue for in a position where they would have to litigate that. So I think by putting a number to it, we thought about cost, and I don't think that that's going to be a burdensome cost based on what I've heard from superintendents. We thought about safety issues, and that's why there's language in there about safety and not having too many products in a cell. That's actually very near identical language in the House and Senate version. But it does come down to, perhaps it would be burdensome for a jail to keep track of that number if they kept to that ad hoc system. But that's really the point, what we're trying to move away from, is that it would no longer be burdensome to make sure they got a basic or minimum number if they implemented a system that we see as a best practice at the prison and many other jails. So those are the three differences. I'm happy to take questions. I lay them out here, but happy to take questions.
Seeing none, thank you very much for your testimony and,
Thanks.
and preparing this for us. Anyone else? And the chair recognizes Commissioner Helen Hanks.
Good afternoon, Honorable Committee. For the record, Helen Hanks, Commissioner of the Department of Corrections. It's really an honor and a privilege when the state takes the Department of Corrections' longstanding practice and says this is so good, it should be in law. So whether you choose the House bill version or the Senate version, we will continue to do the right thing by those who are in our facilities and who menstruate. I do want to just point out the differences between the two bills. We just talked about key areas for the department are the definitions of a menstrual hygiene product. That does have meaning. We don't want products in that could be used as a tool to actually throw blood at people. On line 16 of the Senate bill, I just want to point out this is an unintentional error. On line 16, it says the superintendent of each county correctional facility. That should say the warden or director of each state correctional facility. Just as a note. And the inclusion of youth is obviously incredibly important. So whichever bill is ultimately the final bill, the department is here to be a resource to acknowledge that this should not be a conversation in correctional facilities, and that I was sitting here thinking, as I do spontaneously every day, that the question of adequate amount versus saying, I'm going to give you 20 of these types of products. If you give 20 of these types of products at a systematic period of time in a month, you're not dealing with someone who, there's always going to be someone who does harm, right? I mean, that's what we see across every profession in the state of New Hampshire, whether you're a teacher, a counselor, a doctor, wherever you are. I was thinking about the term adequacy and really putting a lot of thought to it. You can have a person say, well, you can have 3 today. You can come back and I'll give you 3 tomorrow. You can have 4 today. You can have 1 today. I think we're all just trying to make sure that this conversation in our law passes our reasonableness test and tries to make sure the person that's going to do harm doesn't do harm in the best way that we can handle it for women in these situations in our correctional facilities. And I appreciate you all for thinking about this topic in a way that we wouldn't have anticipated spending so much time on. But ultimately, we're a resource for you. We want to be that. And we would appreciate the definition remaining the same, the correction that I pointed out, and the specific inclusion of youth women who are menstruating in our state. With that, I'm certainly avail myself to any questions or assistance as you navigate this topic.
Thank you, Mr. Chairman. Thank you, Commissioner. I just wanted to clarify, because I've been taking notes since our whole conversation. So 62237A, you would like the verbiage to say the warden or superintendent of each, is that the words that you said?
Representative Rhodes, thank you for that. It's warden or director.
Director.
In state corrections, we do not have superintendents.
Thank you.
Thank you for that question.
And I just have one quick question. I'm sure that you've examined it, but just for me, how is 20 adequate? Or is that generally an adequate amount?
The key important part here is the second following sentence. that we're giving at a minimum a combination of 20 items. And that second sentence that says, an individual may request additional products exclusively based on their person at no cost. That's important. That's critical. They mean something together. They don't mean something apart. So whichever you decide, the approach has to say, we are reasonable. We know you may need more. I will add at the state level, I don't know at the county level, we give these at no cost. And in our commissary, you can choose to buy more, right? We just don't want this to be a conversation when people are trying to seek rehabilitation.
Would it not, and I understand what you're saying, where it says an individual may request, but oftentimes we know that when we request things, we are told no. Would it not be better to say shall be supplied at their request versus?
That makes stronger intent, yes.
Thank you. Representative Murphy.
Thank you, Mr. Chair, and thank you, Commissioner. I just wanted to ask, and I don't know if you can answer this for the county facilities, but if we're dispensing 20, whether pads, tampons, whatever, are the inmates allowed to keep those in their cell, all 20? Would that happen both in the state and county facilities?
I can speak to the State Department of Corrections. That you keep them in your cell.
Okay.
I couldn't speak to the county. I could assume for the county, but I can tell you in state corrections, they stay in your room.
Okay, great.
Or
Thank
you
you.
can
That was
travel with one on your person if you're going to a class.
okay. Thank you. Yeah, I just was thinking about the timeliness. I mean, it's great that we're
Yes.
given 20, but if they don't have access to them, so thank you.
Thank you.
Representative Wheeler.
Thank you, Mr. Chairman. Representative Murphy touched on my question, but when you, so you get 20, is that 20 at the beginning of the month, or I was a little bit confused by something you said, or do you get doled out that 20?
Representative Wheeler, I appreciate the question. I didn't actually say those things. We give them in a steady supply to the person in need. We have a process, but again, we have also a total property policy, which is a larger conversation for comparative, and a person can have in their room a certain amount of property. So that point of not having so much excess of this product, but there's also rules and regulations around excess of other products too, not to be a hazard. So on a regular basis, even if it was daily, we have a system that allows us to respond, but people are not at a point where they only have 20 products in their room and then on day 21 they don't have any. It's a rolling availability, just as it's as normative in our correctional facility as it would be at home for a person who menstruates. You're welcome.
There being none, thank you very much for your
Thank you
testimony,
all.
Commissioner.
Thank you for service to the state.
Is there anyone else wishing to testify on this bill who has not done so? There being none, I hereby close the public hearing. Let me see, what are we at? 1:25, 2:30. We'll be in recess till 2:30. Good afternoon. At this point, I'm opening the House hearing, the committee hearing on Senate Bill 268, and I recognize Senator D'Alessandro to introduce his bill.
Thank you, Mr. Chairman, and distinguished members of the committee. I'm Senator Lou D'Alessandro. I represent District 20, Manchester Wards 2, 3, 4, 10, 11, and 12. And I come before you as the prime sponsor of Senate Bill 268, which will be called Max's Law, to honor a Portsmouth police dog that was killed in the line of duty during a training accident. The Massachusetts legislature passed Nero's Law, which is similar to Senate Bill 268. This emergency medical services are not allowed to provide medical services to law enforcement canines. This bill will allow that to take place. And the Gannon family is here, whose son was involved in the incident. There is an amendment that will be offered. The amendment is a technical one. It doesn't change. It doesn't change the bill at all. We worked hard on getting this done. This was a late file. We brought it in through rules. We got it through the Senate without any problems. It was a unanimous vote. And as I say, Patrick and Denise Gannon are here, and I believe that they will testify. We have a representative from the Massachusetts legislature here who will testify. And with that, Mr. Chair, I will address any queries that you might have. But I'm pleased to be here. I thank you very much for being on time. Can't beat that. And great to be here with my former colleagues from the House. I was in the House many years ago and had a good trip. So with that, Mr. Chairman, I'll address any questions that you might have. And as I said, thank you very much for your attention.
And thank you for offering us the privilege to hear this bill and for your service in the House and Senate. And I don't believe we have any questions for you. We'll just go ahead and listen to the family. Thank you.
Thank you.
The chair recognizes Patrick and Denise Gannon.
Good afternoon. We are Patrick and Denise Gannon. Thank you for hearing us this afternoon. We are the parents of Canine Sergeant Sean Gannon. You have all received a picture, 3 actually, in front of you. This is Sean with his canine Nero when they were in active duty. He was murdered in the line of duty on April 12th, 2018, we're coming up on 5 years, in Marston Mills, Massachusetts, while serving an arrest warrant on a career criminal with over 125 priors. Sean was 32 years old and married for just a year and a half prior to his murder. He was well educated with degrees in criminal justice, psychology, Spanish, a master's degree in emergency management, and many certifications. Sean served as Yarmouth Police Department's first canine narcotics handler with Canine Thor. He led the emergency management unit for YPD and was a member of the proactive anti-crime team for the same department. Following Thor's retirement, Sean acquired a new partner, Canine Nero, a young Belgian Malinois trained and certified in tracking, building, and area searches, criminal apprehension, evidence recovery, crowd control, and handler protection. Sean and Nero worked together for a year and a half before Sean's murder. On the day of the murder, a team of officers that included Sean and Nero were deployed to serve an arrest warrant, completely unaware that the arrest would turn into a barricade situation. The perpetrator was hiding behind insulation in the tiny house of an attic. The attic was unfinished. It was a crawl space. Nero was on the 30-inch lead and pulled Sean to a piece of insulation that led to another piece of crawl space in the attic. When Sean pulled back the piece of insulation to view the space, the killer shot Sean in the head and shot Nero in the face. Sean died on impact. Nero's bullet passed through his face, dissected his trachea, and landed in his shoulder, where the bullet still remains. While de-escalation tactics were implemented in an effort to prompt the killer from his hiding place behind the insulation, Nero lay critically injured in the attic, swallowing his own blood for 3 hours. After the murder was coaxed from the house and placed into custody, 2 master canine handlers cut a hole in the roof of the house to rescue Canine Nero from the attic space.
Under Massachusetts law, at the time, emergency medical care and transportation to a veterinary hospital for Nero was not permitted. The unit commander at the scene made, quote, one of the most difficult decisions of his life, end quote, and placed Nero into his cruiser. An emergency medicine physician who was also at the scene went into the cruiser, and together they rushed Nero to a veterinary hospital. By this time, Nero was gasping for air. The physician intubated Nero with a drinking straw, which was the only tool that he had available to him in the cruiser that enabled Nero to breathe. The prolonged delay in access to treatment seriously jeopardized Nero's chance of survival and inflicted hours of suffering for the dog. In fact, you wouldn't have those 2 recovery pictures of Nero today had that unit commander not enabled Nero to be transported in a cruiser. Nero would have died. Nero underwent surgery that night and spent weeks with canine officers sleeping with Nero in his cage around the clock. Nero was despondent until Sean's widow placed one of Sean's shirts under Nero's head. For the first time, Nero's tail slowly wagged when he smelled Sean's scent. When Nero was released from the hospital, one of the first things Nero did was climb into his cruiser and licked the headrest where Sean's scent remained. These are illustrations of the bond that exists between a canine and its handler. At the time, Nero was fairly new in his career as a patrol dog, but unfortunately the extent of his injuries combined with the traumatic circumstances forced Nero into early retirement. Delays in care of this nature, combined with a possibly unnecessary retirement, do not need to be repeated for any canine in any law enforcement agency. The events that occurred came at a significant cost to the Yarmouth Police Department. The acquisition of a canine animal, the extensive initial and ongoing training for both the canine and its handler, in addition to the daily care and support, require substantial monetary investments. These investments are completely lost when a wounded canine cannot receive timely care that could result in recovery and a return to duty. The emergency care and transportation of a canine that's wounded in the line of duty are cost savings measures. Since its passage in Massachusetts, Nero's Law has been invoked twice, once in July and most recently in December. There is a need for a law of this nature. In Massachusetts, teaching and training is ongoing for Nero's Law across our cities and towns.
Canines live and work and die for their handlers, as we saw in the case of Canine Kit when he dove into, he saw what officers did not see initially and dove right into the gunfire and saved 3 officers' lives. Kit was killed instantly. They work 24/7, 365 days a year. And if the officer has a family, the canine becomes a member of that family. So I ask you, which one of you would let a beloved family member who serves the public suffer and be close to death and not rush to acquire immediate emergency medical help? There are some things that have happened that we can't change. But this law is something we can change, and we have changed. Massachusetts, Rhode Island, Maine, Connecticut's effort is underway. Across the country, we see rapidly growing interest among first responders, veterinarians, and the general public for needed legislation like Max's Law. In fact, 46% of all states have either passed a version of Max's Law or have similar efforts underway. Colorado led the way. We hope that New Hampshire will follow suit with Max's Law to support canines, their handlers, law enforcement, and the public. In the posthumous credo of our son Sean, let's do the right thing. Thank you very much for hearing us this afternoon. Do you have any questions at all for us?
Seeing none, thank you very much for sharing your story. And on behalf of the committee, we're sorry for your loss.
Thank you very much.
At this time, the chair calls Representative Ziaros. I got that right?
Close enough, sir. Good afternoon, Chair. Through you to the members, it's hard for me to sit here and listen to that. So before I became a state representative, I was Sean's boss. So I'd like to tell you my story, and thank you for sitting next to me. So I respectfully urge you to issue a favorable report on your bill known as Max's Law. It has very special meaning to me. It's very personal. Massachusetts passed it last year on the anniversary of Sean's murder. And I'll tell you a little bit of the story. You heard from Mrs. Gannon and Mr. Gannon. I mean, those are the parents of a murdered police officer that I sent on that call. It was, so Nero's Law is inspired out of tragic events that took place on April 12th, 2018. Back on that day, I was the Deputy Chief of Police for the Yarmouth Police Department. We received information that a violent career criminal with 125 prior charges was at a house. He was wanted on outstanding warrants. We had information that he was armed illegally, and we knew him, and we knew he was dangerous. And I sent those officers on that call. And I heard them screaming on the radio for help. So I raced as fast as I could to the scene. I learned that K-9 Sergeant Sean Gannon had been shot in the head and taken from the scene. And then I learned through my radio that he had died at the hospital, despite everyone doing their best. And looking back, he probably died at the house, but they rescued him and did everything they could to save him. But meanwhile, the shooter was in the house, and so was Nero. And the SWAT team came, and help came from everywhere, and I was right there the whole time, from 3 o'clock in the afternoon till probably 1 in the morning. And Mrs. Gannon talked about it. But after the suspect finally gave up, we knew that he had murdered my officer, my brother, and we knew that he shot Nero. And he walked out of that building with his hands up. I'll never forget that sight and that feeling, and seeing our officers take him into custody. And but the mission wasn't done. We needed to find Nero, and we needed to make sure there was no more killers in that house. So the SWAT team went in, and they do what they do. But I'll never forget the sight of them carrying out Nero. You know, he was still alive. And, you know, gasping for air. He was bleeding to death, choking to death, and nobody could legally help him. All the EMTs, all the paramedics, all the ambulances sitting there, their hands were tied. So the police took over, as mentioned. A doctor from the SWAT team jumped in back of a cruiser. Peter McClellan, a retired Yarmouth officer who was called to the scene, because we knew if Nero was alive, somebody would have to handle him. And Peter was a canine handler. He raised Nero as a puppy, and he gave Nero to Sean. So a Barnesville police officer drove a cruiser. A doctor sat in the back. Nero was on Peter's lap, and they did the best they could to keep him alive. And he was transported to the veterinary hospital because there was no other option. And for a week, police officers never left Nero. Peter McClellan slept in the cage with him at the hospital. Canine officers guarded the building. And I was there when that picture was taken that you may have. We knew that Nero was coming out, and we ordered Sean's cruiser to be brought to the scene. Sean's cruiser. And when Nero came out, I was standing right there. And he was so skinny. He's covered in scars, stitches. And I saw his eyes, you know, staring at Sean's cruiser. And he was looking for Sean. And then I opened the back door where the Nero goes. And he jumped right in. And he started licking Sean's headrest. So after we laid Sean to rest, and after I handed the folded flag to Mrs. Gannon at his grave, we just kept working and doing what we could to heal our officers and honor Sean. And we wrote a bill called Nero's Bill with the help of veterinarians and people and police officers, and Rep. Crocker was the representative at the time. I was a police officer. but it didn't pass. So that was a message to me that after 40 years of serving, I needed to retire from the job that I loved and run for office to do something I've never done. Probably a lot like you, we run for office to serve and protect and to help. And for me, it was to right a wrong. And it's not easy to make a law. There's no such thing as a no-brainer. It failed the first time, and then I filed it. And honestly, I never worked so hard to bring people together, to get co-sponsors, to tell the story of Sean, just kind of like we're doing today. And for me, as a rookie representative in Massachusetts, we got it done in 10 months. And I thank Governor Baker and all my colleagues for coming together to do the right thing. And then there was the matter of, well, where do we do the signing of this bill that took so long and so much blood? And I asked Governor Baker if he would come to Yarmouth Police Headquarters and sign it on the day of the tragedy. And he said, Steve, I would be honored, but is that okay with the Gannons? And they said yes. So if you can just picture 4 years to the day, Governor Baker, Lieutenant Governor Polito, all my colleagues, Mrs. Gannon, Mr. Gannon, Sean's widow, Ann Nero, and about 50 police dogs, and everybody was there. And not at Yarmouth Police Headquarters, but behind it, where Sean and I stood in the woods about 5 years ago. And he said, Deputy, what if we cleared these woods and we made a canine training center? Because we should be able to train our dogs right here. And then he was murdered. So we cleared those woods. And we built a $1 million training center. It's called the Canine Sergeant Sean M. Gannon Police Canine Center. And that is where the bill was signed, in that building. And I'll never forget it. It's doing the right thing. And as they mentioned, since then, 3 dogs have been shot in Massachusetts. So Nero was one. Canine Kit was a Braintree dog. Was involved with a shootout, and he took the bullets instead of the officers, and he was murdered. And they could not treat him because the bill wasn't signed yet. But once the bill was passed, Canine Frankie, a state police canine, was shot to death, saving his troopers. And I got a text that night from the state police saying, Rep. Exaros, we're just leaving the crematorium with Frankie's body. But we want to thank you for passing that law, because he was treated, he was transported in an ambulance, and he was given every chance to live, and he died with dignity. So we're here to ask you to support this bill, to give you some of the backstory. These animals are not just animals, they're police officers, they're partners. They deserve our protection, and I ask for your support. Thank you. And if you have any questions, I'd be happy to answer.
I don't see any. Thank you very much for your testimony.
Thank you, sir.
At this point, the chair recognizes Mr. Bill Werner.
Good afternoon, Representative Roy, members of the committee. Thanks so much for giving us some time today. I'm sorry I'm gonna have to sit with my back a little to this side. I don't fit in this chair, so respectfully, maybe wider chairs. Thank you so much. So my name is Bill Werner. I'm here representing the Portsmouth Police Department in support of Senate Bill 268. First and foremost, I'd like to just touch on where we're asking that you accept the bill as it sits before you, just with one amendment that Senator D'Alessandro had referenced. If I could direct your attention to line number 20, the last two words in that sentence, ambulance services, we'd like to strike those and replace them with the word treatment. So that is the one technical amendment that was mentioned earlier. Going around the room, I was able to submit written testimony for two individuals who couldn't be here today, both who are in support of the bill, both Brandon Skoglund, who represents the Elliott Hospital and EMS, as well as Benjamin Foster, who is a canine sergeant with Manchester Police Department. So their written testimonies are coming around. As a canine handler in the city of Portsmouth, as well as an operator on the Seacoast Emergency Response Team, I've had the distinct opportunity to work with these animals that are beyond amazing in their abilities. All around New Hampshire, we have operational canines demonstrating their capabilities, from our detection dogs who can smell the smallest amounts of narcotics, explosives, or accelerants, to our tracking dogs who are asked to find Alzheimer's patients or small children who have wandered sometimes miles from their homes, to our patrol dogs who help locate and assist in the apprehension of violent criminals, to even our comfort dogs who are there for people in their time of need in a way that humans simply cannot be. As a handler of a patrol dog, and you have a picture of my dog also named Frankie, this Senate bill has a very different meaning for me, as opposed to that of maybe a department's administration, who may be looking at the financial aspect of losing a dog, or societies want to protect all dogs because we love them. As a patrolman and a member of the SWAT team, I'm frequently called on, sometimes in the middle of the night, to respond to the most dangerous of situations. And once on scene, I ask Frankie to quite literally become the tip of the spear. I ask him to go first into the unknown while his humans are 40 plus feet behind him. Sometimes I even ask Frankie to go in alone while I wait safely out of sight. And without question, fearlessly, Frankie will head off into the dark unknown because I asked him to. And he'll do this so that he can first encounter whatever danger may be hiding in a corner or behind a door or lurking in the shadows, so that he can take the bullet or the knife or the punch or the kick, so that his humans don't have to. And this bill will be our way of showing these brave animals that we appreciate their efforts to keep us safe, and that we're willing to do whatever we can to help them in their time of need. So I would ask you all that you find Senate Bill 268 ought to pass. And thanks so much for your consideration. I can also answer any questions that you may have from the canine handler's point of view.
Seeing none, thank you for your testimony. Well, what did I miss? Representative Newman.
Could you just repeat what you said about what the change is in the amendment?
Yes. So line number 20
In the amendment?
in the bill that sits before you, line number 20, the line reads, injured in the course of their official duties and no human needs transport, or those last two lines, ambulance services.
Okay.
We'd like to strike those and replace it with the word treatment.
Thank you.
Just further clarification, because I think we're a little bit confused on this side. So the ambulance services that you're seeing is on line 24. That's what you're looking at?
Hey, hello.
Oh, okay.
Yeah, if the members could just hold off the technical questions, we have an amendment in the works that encompasses everything that's being discussed.
I see. That's where our confusion came.
Yeah,
Thank you.
no problem. Any further questions for the officer? Representative Sitek?
As a matter of interest, how long does it take to train an operational dog?
I'm sorry, Representative. Say that again.
How long does it take to train one of these service animals?
So, for most departments here in southern New Hampshire, we all train with the Boston Police Canine Training Group. So, for a training for a patrol dog, we go down to Boston every day for 14 weeks, dog and handler. So, the certification at the end of that 14 weeks is for the team. So, if that dog were to go to a different handler, they would have to restart that program. Once the 14 weeks is done, many patrol dogs here in the state are dual certified. So they have a secondary certification. So for Frankie, Canine Frankie, his secondary certification is that of explosive ordnance detection, EOD. He's a bomb dog. So we had to go back down to Boston for a 10-week program. Once those two certifications are done, the dogs will have to pass annual recertifications put on by national organizations. To keep our status with the Boston Police Training Group, we also have to go down to 2 8-hour training days a month. And that's just formal training. That doesn't count the daily training that a handler will put his dog through just to ensure that if they do get the call, the dog is ready. All of that training is also documented. So the pages and pages of training sheets reflect all of that training.
Thank you for your testimony. Chair recognizes Stacy Ober.
Good afternoon, Chair Roy, members of the committee. My name is Stacy Ober, and I am the New England Manager of Government Relations for the American Kennel Club. We were founded in 1884. We're a nonprofit canine club that is widely recognized for canine breeding, training, and responsible dog ownership. We represent more than 5,000 clubs across the country, including 13 here in New Hampshire. And back in 2021, AKC licensed and sanctioned 150 events in New Hampshire where more than 26,000 dogs participated. I'm here in support of Senate Bill 268. I want to just acknowledge that AKC educates and supports the breeders of these high quality dogs that are bred for their predictable type, their instincts, and their temperament to perform these important roles. We value the contribution that these working dogs make to national security and the extraordinary role that these dogs play in protecting the peace and security of individuals, communities, and nations against threats. And we honor the breeders, trainers, and handlers of these dogs. To ensure public safety and national security, we support expanded scientific research and breeders who ensure that sufficient numbers of high quality domestically bred dogs are available. And we're asking you to pass Senate 268 so that specialized care is provided to assure their well-being. I know a layperson may be contemplating what would be the difference, for instance, in emergently transporting a police canine in a cruiser with the lights on versus an ambulance that's able to get there expediently. And I just wanted to emphasize that our emergency medical personnel have the skills, for instance, to pack a wound, open an airway, do certain life-saving skills that a police officer wouldn't necessarily have. And that's the benefit of knowing they already have the basic skills to be able to provide life-saving treatment while the dog is being emergently transported. I also wanted to acknowledge that our affiliate, AKC Reunite, works with our AKC clubs to donate police canines to police departments around the United States. Many police canine units are suffering budget cuts and they're unable to solicit money due to town and municipality codes. And so the donations from AKC Reunite and the AKC clubs allow the police department's need for a new canine to become a reality. a maximum of 1 grant per department, and a total of 250 grants will be awarded in 2023. This is a 3-to-1 match grant program up to $10,000 in response to the Braintree, Massachusetts Police Department losing K-9 Kit, for instance. We were able to produce a check for $10,000 to go towards replacing their police K-9 for them. So I did bring a copy of the application if anyone's interested, and it's available online as well for anyone that might have a community that's looking to acquire a police K-9. So I thought I would mention that as well.
Thank you. Do you, if you know, how many facilities do we have in the area to treat emergency treat canines who are injured?
That would depend on how many emergency veterinary clinics you have. And I expect someone behind me probably could answer that. In Massachusetts, they're kind of geographically by region where they're available. And on the implementation of Nero's Law, the protocols would lay that out in terms of what's the nearest emergency veterinary clinic to you.
Thank you.
Mhm.
Representative Prue.
Do you know of any training for the EMTs that are in these ambulances for the dogs? Because I've only seen one course. I tried to sign up for it and it was full before I could even get there.
Well, I think it's kind of the concept of if you build it, they will come. Once the bill passed in Massachusetts, for instance, Robert Kraft made available Gillette Stadium, and they had a large training that was put on there. I think there were 4 groups of 40 that rotated through. So it may not be readily available now, but I imagine that once the bill passes, again, that would be part of the implementation. I know a lot of our clubs also will donate, for instance, canine muzzles and other equipment that might be necessarily that's not readily available, but the handlers themselves would have on site for their police canine that kind of equipment, where it would be readily available as well.
Thank you.
Thank you for your testimony.
Thank you.
The chair calls Anna Batchelder.
Good afternoon. My name is Dr. Cara Batchelder, and I'm here today in support of Senate Bill 268. I've been employed as an emergency and critical care veterinarian at the Veterinary Emergency Center of Manchester for about 9 years. And during that time, I've had the privilege of working with the Manchester Police Department's Canine Unit, which has allowed me to see just the unique bond that these dogs and their handlers have and how important it is to keep them healthy and fully able to function at their job. So, unlike your typical house family dog, these dogs are in unique high-risk situations that potentially can result in life-threatening injuries or exposures. And this can include anything from gunshot wounds, stab wounds, heat-related illnesses, illicit drug exposures and intoxications, burn injuries, and other blunt force trauma injuries. So unfortunately, in most instances, our veterinary community doesn't have the resources to respond immediately to emergencies when they occur in the field. And as a result, there's a large gap that exists in the provision of care for our operational canines on scene at the point of injury and during transport to a veterinary facility. The military has been using their medics to perform field triage, stabilization, and transport of their operational canines for quite some time with very good results. And so while there's not an organized veterinary emergency medical services program here in New Hampshire, similar to military medics, our EMTs and paramedics are in the ideal situation to close that gap in care and perform the necessary tasks to stabilize the dogs in the field. So as a result, when the dogs reach a veterinary facility, their odds of a successful recovery are significantly increased. 2 of my colleagues and I attended an extensive 3-day course in Portland, Maine on advanced first aid for operational canines. The goals of this course were to teach handlers and emergency medical responders how to recognize situations where pre-hospital care was indicated, how to stabilize the dogs, and try to avoid preventable deaths. So it was amazing to see during this course how the EMS personnel were able to, with just a little bit of guidance, take their already existing skill set and tools and just translate them into canines. My team and I are working with our New Hampshire EMS teams here to set up a similar program for training, so that hopefully once we get everything in place, we can start rolling out training for our own handlers and EMS. And hopefully this will allow us to close the gap in care and provide the care that our operational canines in New Hampshire deserve. So I thank you for considering Senate Bill 268 and can certainly take any questions if there are any.
If I could ask you the same question I asked before, how many facilities are available in New Hampshire to treat canines on an emergency basis, like an emergency room type thing?
Yeah, so there are 8 ER type of hospitals that in theory could perform most of these skills. There are 3 hospitals that contain specialists, so like boarded surgeons, criticalists, anesthesiologists, the more advanced skills. And then really any general practice could do, your basic stabilization if needed. So especially for up north where there's not as many hospitals, if they needed to go there first and then be transported later to a specialty facility, that certainly is an option.
Is there like a rotating schedule, like which ones are open 24 hours so that the officers know what the closest one to them is at any given time?
So I have a list that I have to provide to our EMS for once we get our training program in place. Unfortunately, because there's a shortage of veterinary staff, not every place is open 24 hours consistently. So we'll provide that to them so that any first responder who goes will have that as part of their, they have EMS protocols, so that could be included in there potentially if they need to.
No further questions. Thank you. The chair recognizes Justin Romanello. Justin Romello.
It's been butchered worse, so thank you. Good afternoon. Really just a couple of clarifications and certainly here for a question. So my name is Justin Romanello. I'm the chief of the Bureau of EMS for the state of New Hampshire. We regulate all EMS providers in the state. So I don't have the numbers, but I will tell you what has changed in the bill before you. So under the first section, which is definitions, we are removing emergency providers, that definition, and we're removing treatment definition because that's previously defined in 153A2, which is the definitions for all of RSA 153. And that changes the order. So you only have 3 definitions for law enforcement officer, which is A, B is going to be operational canine, and C would be official duties. The only other change under definitions would be within the law enforcement officer section, and that's referring to the appropriate RSA that will define what a law enforcement officer is, and then it adds, as you read in front of you, the addition of National Guard to that, and that's what Officer Warner was, I believe that's what you were referring to. And then the second change that actually Officer Warner was referring to is under Section 2. And it's the last phrase in Section 2. It removes ambulance services and it adds treatment. And that would be in line with other language within the language. There's no such thing as ambulance services in the state. It's treatment and transport, if that makes sense. And then I'm certainly available to answer any questions. I think there's a couple of questions that you've already previously asked that I could answer and put more guidance to. Sure.
If you heard a question you wanted to answer.
So the way we see this, if this is passed, it will fall within our normal EMS protocols, and it will be what we call a prerequisite protocol, which is an additional protocol that EMS providers have available to them through their licensed units. And what that allows for is relationships. And so it encourages relationships between the officers, so the law enforcement officers that have the canines, and our EMS providers and the units, as well as the hospitals. So who's going to be available 24 hours a day, and other services that may be needed. So there's an additional application process for our prerequisite protocols. So the division, as well as the boards that provide guidance for EMS within the state, all understand that everybody has the appropriate oversight. The relationships are there, so there's nobody kind of left high and dry. And so, to your question, as far as the number of hospitals, the way I view the prerequisite protocol, it's going to outline all the hospitals that are available. And then, as an example, for Manchester Fire as a non-transport EMS agency and AMR as a transport agency, will understand what hospital that the canine handler prefers for their canine, what's available at a given time. So all this will be kind of ironed out within that prerequisite protocol in that application process. That's really the only other clarification. Unless there's any questions, I certainly can answer anything for the EMS system.
Representative Selig.
Thank you. I'm just thinking back about all of the different testimony. I recognize that obviously if there's a human who needs transport to an emergency room as well as a canine, that the human should get it first. Is it possible within an ambulance to have them both go? And that's just a practical, I've not been inside an ambulance except to take my kids on tours, so.
Sure. So there's many different types of ambulances that are out there. Some are easier to transport multiple patients than others. I think that the treatment and transport are two different things, right? And so the ability to treat is the one piece, and then how we can transport, and I think there's flexibilities within that. So if there was a situation where there's no access to an ambulance immediately and the canine needs to be transported, we have the benefits of having a left and right to treat, and then we could find potentially other vehicles at that time. But I think what this bill does is it provides that left and right to really say this is at the EMT level, what treatment modalities can be done, at the advanced level, at the paramedic level, where we didn't have that before. So it wasn't only just the ability to whether to treat and transport or not. It was kind of the wild west, right? And so we've seen in other states where this provides that left and right. And yes, absolutely. If there was a case where we need to transport, two people, a person and a canine, we certainly could do that.
Yeah, just they go to two different places, obviously.
Sure.
So if you were transporting two, obviously the human would be dropped off, and then the canine would drop wherever is that
Yeah,
correct?
I mean, I think that it's what we certainly don't want to do in any type of, whether it's admin rule that we create off of this or protocol is say that you have to do this in a particular order. Like, there's got to be some flexibilities for our providers, and I think our EMS protocols and our patient care protocols allow for that flexibility in what's best at the time for all patients and what's available at the time for all transport modalities and that sort of thing. So I think we have that flexibility in here to ensure everybody's receiving the care that they need and have access to transport mechanisms. And, my thought is in some of these instances, you might, have, if you have a potential for a couple patients, you're going to have some ambulances standing by potentially, assuming it's available in the system. Again, that treatment is key. I think in any case, there's if we didn't have the ability to treat appropriately with the training, if there wasn't an ambulance available, our providers, might have been a little flustered at the time, where now they have treatment modalities and potentially have treatment modalities in place so they could stabilize until, that next ambulance is available.
Go ahead.
I'm wondering, Mr. Chair, if we need to add something in the amendment you were talking about that just says, that sort of gives the flexibility in terms of co-transporting if that's the only option. I just don't know if we need to add that in.
I'd prefer to leave the flexibility to the commanders on the scene, as long as it's not prohibited for them to make the call on the ground versus dictating from here. But we'll look at it. Representative Muse had a question.
I understand that in Massachusetts, there's some training that was required on the part of ambulance drivers, and the effective date on this particular bill is immediately upon passage. Given the experience in Massachusetts that you've had a chance to see, what is your opinion around the effective date? Should we leave it as is, or should we move it?
Sure. I apologize. So I think much different than how this is written compared to what Massachusetts did. I think so. Massachusetts basically said that every licensed unit, every provider must treat and transport a canine. And I think that whereas it allows for us to put it into a prerequisite protocol and allows for a licensed unit that may support canine operations. So I'll use Manchester as an example. It allows them to provide care. So we're not going to have 301 services, licensed units providing care. We're giving them the flexibility to decide if they want to do that. And so with that, again, I keep saying the prerequisite protocol, we can outline what skills are going to be, or what scope of practice and treatment modalities are going to be allowed at any particular level, and then it's the departments that's choosing to apply for this. It's their job to then go out and get that training. And I think we could support it as a state. We could provide it. We can't certainly support the entire state to provide training. We don't have to with the way this is written, but we can provide access to the various programs that are out there, and there are quite a few. And so like a department that just has EMTs, they're not going to need a 3-day course. Massachusetts, I believe their entire curriculum with the practical portion and the online portion is about 4 hours. But I think that different with Massachusetts, this is allowing our agencies to do it if they wish, and our providers to do it through those agencies, but it's not every single service is going to they have the opportunity, but they don't have to do it, if that makes sense, sir.
And one quick follow-up. I'm not sure you answered my question just around the effective date.
Sure. So as of once this becomes effective, our departments and licensed units will have the ability to do it, and then we will give them the protocols and all that through our normal protocols. So even though it's effective, at that point they still have the opportunity to apply for it, and we still would be able to satisfy any needs. I don't believe we need any type of grace period. The only other piece to this, and it's only from my perspective, is that I believe that the Board of Veterinary Medicine is going to have to make modifications to their administrative rules, and we will work with them to put in interim rules. But again, that's just from my perspective, because they have the Veterinarian Practice Act that's going to have to, they're going to have an administrative rule, the 308, that's going to allow for EMS providers to be waived from providing care under that act. There's other avenues of EMS care that we do that. One of those is mobile integrated healthcare. We have a waiver in place with the Department of Health and Human Services that waives licensed EMS providers from having to be licensed as home healthcare agents. And that's to facilitate us providing community paramedicine and mobile integrated healthcare. And I see the Board of Veterinary Medicine and OPLC having to add in administrative rules under 308 to facilitate that. But as far as timelines, I certainly can't speak for another agency.
Thank you.
Representative Prue.
So my question is, my police department has a dog, so we're probably going to jump in on this. But if there's a department that doesn't have a dog, probably say, hey, we don't need to do this, but the next town over comes in and their dog's there. If they're not in that protocol, are we prohibiting them from transporting?
So I don't think so. I think my colleagues in the back, the state police, they have 20 operational dogs throughout the state. They're all over the place. I think that departments that cover larger areas will have to, and we'll certainly work with them to foster those relationships, but they're going to have relationships with multiple other departments. And I think, down the road, I was speaking with the Gannons before the testimony. I think, once down the road, we'll find that there might be some baseline protocol that we can issue, like CPR. That maybe every department will, or every provider should learn that. But I think at first, starting with this, seeing how many departments are going to take part in this, really finding out how many dogs and departments are out there that own canines or operational canines. I think at one point or down the road, we might get to where it's a general protocol to take care of that. But for right now, it's going to be, if Nashua has a canine, obviously Nashua Fire Department as a non-transport, AMR as a transport, but it might be advantageous if they find that they go to other communities, to provide, maybe the SWAT team goes out to provide services to Merrimack. Well, maybe Merrimack Fire would need to take part of this. And we have other prerequisite protocols, specifically going back to mobile integrated healthcare, where multiple departments are taking part in that specific protocol. So I really think that it can work.
Follow up. So what I would like to see is that they can at least transport. They may not be able to apply any care, but I think just putting them in the bus and transporting them is better than letting them sit there or in the back of the cruiser.
So I actually made that note, and so I appreciate that. I was thinking about the same thing. So I mean, the bill as written, right? And if it goes into RSA, it will allow for the treatment and transport. So any ambulance. So we have 476 ambulances, give or take, right about now. 167 transport and licensed transport in units. So that gives them the ability to transport. It makes that appropriate. And so what I could see is going back to the Nashua example. So Nashua SWAT team, they're a licensed non-transport service in the state. Their medics could actually take part in this prerequisite protocol, and so it's allowing their medics to be the treatment perspective, and then AMR as the contracted contracted transport service has the transport. They work synergistically together, and the injured canine gets to the appropriate resource. So I think that we don't need to make any modifications to facilitate that. That's here, but absolutely it would be.
I didn't want to see a rule prohibiting it.
Yeah, no, I don't think so at all, sir.
Thank you.
Thank you, Mr. Chairman, and thank you for your testimony. It's been very informative. Are you aware of any good reason as to why it's currently illegal to transport a critically injured canine?
So, from the Bureau of EMS, Division of Fire Standards Training, EMS, in within 153 and 5900, I do not see anything. However, in learning more about this, what is prohibited right now is the Veterinarian Practice Act, which is, through the vets. That I would say is prohibitive, because that's saying specifically that any treatment is required to be a veterinarian or a veterinarian clinic technician. So I think that what this bill will do is make sure that there's some sort of waiver in place for our providers to provide that care, which to the Veterinary Care Act, but then it also provides that left and right I made mention of earlier. Like, I think, our protocols are robust for human patients, and it allows, our providers to treat all patients in statewide EMS protocols, and we can do a lot, and we need that left and right, I think, for our canines. There's a reason why there's a board of medicine and that sort of a board of veterinarian care. So I think it's important, and I think that's why it's much needed.
Thank you for your testimony. Oh, who's left?
So is that something we should put in this bill that repeals that veterinarian part?
I don't, in my opinion, I don't think we need to repeal it. I think what this RSA will do, and we've seen it in other places, I made mention of the MIH piece. So 153, that's obviously it's an RSA, it's a law, and that's going to facilitate change within the administrative rules for the veterinarian boards. And so I think this is fine the way it is, because it's a law. Even though it's a law that governs, EMS, I still think it needs to be applied to those administrative rules.
Because I'd hate to run into a roadblock.
I don't think I've looked into it. I've spoken to my colleagues. I don't think we need to change anything. So. I appreciate your time. Thank you, sir.
Is there anyone else wishing to testify who's not testified on this bill? Seeing none, I hereby close the public hearing. Can we do that? Only if you're going to clean up. 251, right? At this point, I'm open to public hearing on Senate Bill 251. And recognize Senator Whitley. If everyone could please move out. Hello? Oh, thank you very much. I appreciate it.
No problem.
You can't have this dog.
Great. Thank you so much. Thank you, Mr. Chair. Good afternoon again, members of the committee. For the record, my name is Becky Whitley, and I'm honored to serve Senate District 15, which includes Concord, Bow, Pennacook, and Hopkinton. So today I'm proud to introduce Senate Bill 251, establishing a committee to study the long-term impact of the New Hampshire adult parole system. Folks in this committee may be well versed in what the system does, but if not, probation and parole is actually designed to lower prison populations and help people succeed in the community. But we have new data available to us that is suggesting it might have the opposite effect. The Council of State Governments, again, who was actually just recently here in the state, their Justice Center recently engaged corrections and community supervision leaders in 50 states to develop the first complete picture of how probation and parole violations make up states' prison populations. The Council of State Governments analysis showed that 45% of state prison admissions nationwide are actually due to violations of probation or parole for new offenses or technical violations. So folks may be well aware that technical violations such as missing appointments with supervision officers or failing drug tests account for nearly 1/4 of all state prison admissions. I think that was a pretty startling statistic when I heard it, and I was pretty shocked about it. But actually what was even more startling to me was the statistic in New Hampshire. Whereas nationally, it's 45% of our prison population are due to these probation violations. In New Hampshire, 60% of state prison admissions are due to supervision violations. And I think that disparity with the rest of the country tells me that it's really time to just study this issue in New Hampshire to make sure that the entire system has the impact and the effect that it was designed to have. I think a committee could answer questions like, how many people in New Hampshire are on probation or parole? How are technical violations handled in New Hampshire compared to other states? What impact does supervision violations have on our local jails in New Hampshire in terms of costs? How do New Hampshire policies impact the length of time that people are on probation and parole? What types of new offenses are people on supervision being sent to prison for? What has New Hampshire done to scale up implementation of supervision practices and programs designed to actually reduce new criminal behavior? And of course, what's important for this legislature to consider is how much do we invest annually in supervision? And how much do the supervision violations actually cost our state? So I think it's also important to take the opportunity to review best practices. What does the research tells us that is most effective? And for this legislature to make recommendations and practices that will help deliver better outcomes for people who are on or under supervision, for families, for our communities, to ensure that all the money that we do spend on this system is used efficiently. I'm happy to take any questions, but I am certainly not an expert on this issue. I think it's worthy of study based on this data that we have seen, but I am happy to take any questions, and I ask for the committee's support of this bill. Thank you.
Thank you, Senator. You probably are an expert on scheduling. Do you think that we will have enough time to give this a serious look between now and the deadline, or do you think this would be better as a commission?
So we did put, thank you for that question. We did put it as a committee. I think commissions can be, they have their benefits in having more people at the table, but they can take longer. I think we have all the data at our fingertips. We just have to collate it, which is why we thought a committee was better suited to do that.
Okay, thank you.
Thank you for the question.
Representative Wheeler?
Last question of the day, Mr. Chairman, and I thank you for recognizing me.
Don't make
Senator,
promises
could
you can't keep,
Oh,
Representative.
that's okay, thank you. But I just wanted you to repeat the statistic that you said at the beginning of your testimony. It was 45% to 60% in the state, but what was?
So it was the Council of State Government. Their analysis said that 45% of state prison admissions nationwide are due to violations of probation or parole for new offenses or technical violations. But in New Hampshire, 60% of state prison admissions are due to supervision violations. So it's a pretty dramatic difference.
Representative Muse?
Thank you for taking my question. Are you aware that the legislative budget assistant did a pretty comprehensive review of the parole system? I think it was in 2019. And have you had a chance to look at that? And do you think it would be something that would factor into what you would like this commission to do?
Yeah, I'm aware of it. And I think it would absolutely inform the work of the committee. Thank you for pointing that out. Yeah.
See no further questions. Thank you for
Thank you.
bringing us the bill. And the chair recognizes Mr. Joseph Lescaz.
Thank you, members of the committee, Mr. Chair. My name is Joseph Lescaz. I will be representing the American Civil Liberties Union and myself in full support of this Senate Bill 251. You heard many statistics and data points about the parole system specifically for New Hampshire that I don't want to go over. Again, what I do want to highlight, though, is the fact that New Hampshire does rank in the bottom 10% for monthly admissions across the nation. In New Hampshire, I know that we strive for excellence, so to be in the bottom of the nation, especially for a statistic like that, I think is quite embarrassing and problematic for the New Hampshire community. As we heard, around 50% or more of people that are admitted each month to the New Hampshire prison is for a violation of parole. And to the cost of $64,000 annually, myself, when I first started my prison sentence, it was only $22,000. It's at $64,000 now annually to the New Hampshire community payers to fund the cost of incarcerating people. And I think that we have alternative solutions that could be used. One of them being the halfway house system, where there is a 7-day sanction that is allowed for individuals for violating their parole instead of sending them back to the prison system. And last year alone, it was not used once. And so I think that we need to take a look at some of the ways that we are applying corrections, and are we backing the system up, or are we creating blockages for people while they are trying to transition? One of the last things I would like to say in closing is that last year, while we were working on the study committee bill for the truth in sentencing, as a matter of fact, I received a letter from the parole department that had stated what they had done is they had backdated supervisor fees to the day that I had come out of prison. My parole officer, when I first came home, had recognized that I did a lot of volunteer work and chose not to charge me supervisor fees to remain out in the community while I was doing the volunteer work through diversion works and a mentorship program. However, I got a letter that backdated it to the day and said that I owed that money in full, or I would be in violation of my parole, which essentially means that if I didn't pay that money in full, I would have gone back to prison, even though I was in the middle of the work that I was doing. For some people on parole, I just would like to paint a picture of what that does. Getting a letter like that, that's panic. Panic sets in immediately for some people, which then starts to overwhelm their sense of logic and reasoning. And after that panic, they start to compare, maybe the negative experiences they had with the incarceration system as opposed to what they have built out. And then that sets a thought process. And what we need to do is evaluate, are we setting people up for failure through the checks and balances that we have in the system, or are we creating something that's really going to foster positive and forward thinking? I just would like to know, one of the questions to come out of this commission, if this committee is established, is, are we still benefiting from the situations of incarcerated or formerly incarcerated people. I did my time. I served it. I made my mistakes. Do I still have to pay every day to remain out here in the community? Should be a question that I would like this legislator to consider. I'm happy to take any and all questions that you may have.
You're currently wrapped though, or are you still paying supervisory fees?
No, I'm currently still on parole, so I do owe supervisory fees until my parole is ended, and parole cannot be ended till they're paid.
What is and is it the same for everyone, the fee, or is it different by person?
It's different from person to person. It's prorated according to the salary that you make. So the more money you make, the more your supervisor fee is.
Sure. Representative Gathright.
Thank you, Mr. Chair. How often is that paid?
It's supposed to be based on a monthly system. It's based on a monthly system, but that's something that is set up between the parolee and their parole officer. The frequency of payments.
Follow up. So to your knowledge, it's monthly, to your knowledge?
The baseline is monthly, yes. And if the only things that to my knowledge, would impact the frequency of that to increase it would be restitution. I don't owe restitution. I don't owe, if you owe state restitution or if you owed victim compensation or things of that nature, there could be, or child support, things of that nature could impact the frequency, but I don't owe any child support. I don't owe restitution. I don't owe any victim compensation. It's solely supervisory fees.
Were you provided an explanation as to why one said one thing and one said another?
No, I was not.
No further questions. Thank you for your testimony. Anyone else wishing to testify in this bill who has not done so? Seeing none, I will hereby close the public hearing on Senate Bill 251, and we are in recess for the day.